Morning, everyone. It's now 10 o'clock and it's time for me to open this inquiry. So before I go any further, but you can all hear, can you? The microphone's working. Yes? Yeah, good. Thank you. My name's Frances Marnie. I'm a Chartered Town Planner and have been appointed by the Secretary of State to hold this inquiry into an appeal under Section 78 of the Town and Country Planning Act 1990 against the refusal of planning permission by Newcastle Underline Borough Council for the change of use of land to mixed use for the stabling, keeping of horses and as a residential caravan site for 4 gypsy families, together with the erection of a stable building, erection of 4 amenity buildings and laying of hard standing on land at Blackbrook Nursery, Newcastle Road, Blackbrook, Newcastle Underline, made by Mr. D and Mr. T. Clay, J. Wilson and M. Lee. So just a few housekeeping matters. And then I'll say a little bit about the organisation of the inquiry, including the procedure and timetabling. Before we go any further, can you make sure if you've got a mobile phone or a page or whatever, something similar, then it's either on silent or switched off, please. Now, there's no fire alarm tests, I understand, this morning. So if it does go off, then we'll need to exit the building. So perhaps can I ask someone who would be in the know on that to explain what the fire exit procedure is, please?
Go out the nearest exit, which would be these doors, unless exit that way is blocked, and then we will go out the back way. And then the assembly point is at the far side of Queen's Gardens, near the statue of Queen Victoria.
Okay, I think we'll be following you anyway. Thank you. Now, over the last 2 years, the work of the Planning Inspectorate has continued in a virtual forum. We've been undertaking inquiries and hearings via Teams. But for me, this is my first inquiry back in the inquiry room, face to face with parties. And I have to say, I'm very pleased to see you all. So I'm sure the advocates, is this your first one as well? And Mr.
One inquiry,
right.
A number of conspiracies, but yeah,
right. It is good to be back. The council have gone to considerable trouble to create a safe environment for this event. And I hope everyone feels comfortable with those arrangements. So thank you very much to the council. Thank you. The inquiry is being live streamed. It's not being recorded. Now, does anybody intend to record any of these proceedings? No, okay, thank you. Now we've got the microphone system. I understand that you can have 2 microphones on at the same time, and you just press the button, the red button, and it goes red around the bottom of the top of the microphone, so you know that it's on. But obviously we can only have 2 on at the same time, so we just need to make sure that we switch it off when we've finished talking. Now, is the press here? No? Okay, thank you. Now I'm going to move on to those who will be speaking at the inquiry. So firstly, I'd like the advocates to introduce themselves and their witnesses to the inquiry, and I'd also like to know the order in which they will be speaking. I'll then invite those third parties who wish to speak to make themselves known to me, and we'll come back to the extent of their evidence and the timetable and whatnot later. So can I start with the appellants, please?
Yes. Good morning, Madam.
Morning.
My name is Mark Willers. I'm Queen's Counsel, and I'm instructed by Mr. Philip Brown and Philip Brown Associates, who sits to my left. And I'll be calling, I represent the appellants, and I'll be calling the following witnesses, hopefully in this order. First, Dolphus Clee, then his brother Thomas Clee, then Dawn Wilson, and then bring up the rear Mark Lee, and before then calling Mr. Brown himself. There is, you're going to deal with timing at a later stage, but
Yes.
Dawn Wilson can't be with us today.
Okay.
But she'll be available tomorrow, subject to schooling, I think.
Right. Okay.
So perhaps if we can just ensure that she's
Yes.
slotted in at a convenient moment.
Yeah. Okay.
Thank you.
Thank you, Mr. Villas. And for the council, please.
Morning, Mum.
Morning.
It's Jack Smythe. I'm the barrister instructed by the Borough Council.
Mhm.
My instructing solicitor is Daniel Dickinson. I have a single witness who is Miss Elaine Moulton, who's the development management team leader with the council.
Thank you. Thank you. Now, does anybody else want to speak at the inquiry? Yes, sir.
Yes.
Hello. Good morning.
My name is Andrew Mannering. I'd like to make a statement. The fact that
Thank you, Mr. Mannering. Anybody else? No? Okay, thank you. Now, I have a copy of the council's letter of notification regarding the inquiry and a list of those that the letter was sent to. So thank you for that. I've had a number of responses. I don't propose to go through them. It should have been copied through to the parties. They may or may not be on the inquiry website, I'm not sure, but they are. Is that right, Ms. Moulton? They are. Good. Thank you. I also had a number of letters that were submitted at the time that the planning application was considered. Those have been copied through to me by the council, and they will all be taken into account. So just because somebody then didn't write at the appeal stage or isn't here today, doesn't mean to say that their comments and concerns will not be taken into account. So please be assured of that. Now, there is the inquiry library, which the council have set up, which is very helpful, and documents, core documents and other documents relating to the inquiry are published on that website. Perhaps can I just ask the council just to explain how to get to that in case anybody wants to interrogate it?
Well, yes, there are links within the notification. So if you have access to the notification letters, you should be able to link into the document. But alternatively, you can go onto the council's website, go through the planning pages to track and inspect an application and put in the appeal reference, which is 21//00001/refuse, and that will pull up the appeal document library. In the document section, you can view all the associated documents.
Thank you. That's very helpful. Thank you. Now, I should explain that during the inquiry, we will discuss what conditions should be imposed if the appeal is allowed. But I must stress that that does not prejudge the case. It doesn't weaken the council's opposition to the proposal, but it is a matter we have to deal with. But that will be at a session towards the end of the inquiry. I've got a schedule of conditions, which I believe is an agreed schedule between the parties. Is that right? Yes? Yes, okay. And can I just check that that's on the inquiry website as well, Ms. Moulton?
No, that isn't on there.
Okay.
We will get that on there today.
Could you, please? Yes, because obviously it's important that third parties have the opportunity to have a look at those conditions. And obviously when we get to that session, if there are questions about the conditions from other parties, then I would be very happy to entertain those. Thank you. Now, this inquiry is currently scheduled for 4 days this week, and I'm very hopeful that we will be able to complete our proceedings within this time frame, including the site visit. So whilst I asked the council and the appellants to collaborate on producing a draft timetable, I haven't received one. Therefore, I'll come back to the anticipated timings for each party in this case shortly. Now, after today, I intend to make an earlier start at 9:30. Normally, we'll have a mid-morning break about 11:15 and an afternoon break about 3:15. I'll also be aiming for a lunchtime adjournment at about 1 o'clock for an hour, but there is flexibility in the timings depending on whether it's a convenient time to break. So gentlemen, obviously, if you're at a point in your cross-examination or evidence in chief where you feel it's only going to be another 5 minutes to finish this or 10 minutes, we'll go on and finish it rather than break, and then you have to come back again. Okay, and obviously if you are in the middle of something, if you keep an eye on the clock, and if there is a convenient time to break, that you actually, okay, I can leave that, I'll finish that line of questioning, I'll move on to the next one, but we'll have lunch in between. Okay, so I'll be led by you on that. Thank you. I don't intend to sit really much beyond 4:30, 5 o'clock at a push, but I think probably most of us will have had enough by about 4:30. I understand the room is available after 5 p.m. if we had to go on, and that we can leave papers here overnight. Is that right? Lovely, thank you. So I hope those general sort of break timings suit everybody. Good, thank you. Now, turning to procedures. So towards the end of this opening, I'll outline what the main issues appear to be at first reading. Then when I've concluded my opening remarks, I will hear short opening statements of about 5 to 10 minutes from first from the council and then from the appellant. Now, the opening statements, what they do is they generally highlight the parties' broad positions. It's a very helpful way of starting an inquiry, particularly for interested parties, because it just summarises the parties' positions for their case before they actually move into the main area of evidence. Now, within those openings, I'm looking for clarification from the council on which reasons for refusal have fallen away. There were a number of reasons for refusal, and some of those the council are not now defending. And I think that will assist third parties to know which particular matters the council will be defending. I hope you got that note, Mr. Smythe, beforehand. Excellent, that's good. After the openings, we'll hear from the interested parties. Those who give evidence will be expected to answer questions on that evidence, and they may be put by the advocate from the appellant, hopefully in a very gentle way, Mr. Willers, I'm sure. Absolutely, good. I may also have questions for them. Then the appellants will be offering a witness to answer any questions from interested parties. Now, these questions will only be on matters that are not being covered by the council. Okay, so that's why it's important that you listen to where the council's position on which areas they're defending. And the ones they're defending on, those are the questions for the council to ask. So if it's something that the council aren't defending on and is a matter that you've raised, then you're very welcome to ask questions of the appellant's witness. We'll then move on, after that session's complete, we'll then move on into the inquiry exploring the cases for the main parties. Now, initially I had indicated I would deal with this on a topic basis. I think as each party's really only got one planning witness, main witness, then I think it will be less disruptive to hear the full extent of the evidence in opposition and then follow that by the evidence of the appellants. So I'll hear initially I'd hear the council's witness giving evidence in chief. So that's the council setting the scene, the expert witness setting the scene for their case. This will then be open to cross-examination by the appellant. Then Mr. Smythe of the council may then wish to ask any follow-up questions as re-examination. I may also have questions to ask, and I hope, gentlemen, you will indulge me. I like to ask my questions as they come rather than wait till the end. Now, if I ask a question that actually you've already got in mind, I know you spend a lot of time putting together your train of thought and questioning. If I'm asking a question that you think, actually, that's 2 questions down on my list, just stop me and say, actually, Mum, I'll be covering that. I'm very happy for you to do that so it's not too disruptive, okay? Following the completion of the evidence in opposition to the proposed development, the process would then be reversed and the appellants will present their case, which will then be open to question by those opposing it. Now that will include from those people who have given me their names. However, that does not repeat the questions of the council, and the questions should be pertinent to the evidence of the witness and not an opportunity to repeat your own evidence, but to test that of the appellants. Now I'm looking to the council to lead the questioning on the personal evidence of the appellants. I don't think it would be necessary for further questioning other than that, other than if I have questions. Now I'll discuss the matter of live streaming this session with the parties later on. Now, after I've heard all the evidence, the discussion on the conditions would normally follow. Closing submissions will then be made, and those are wrapping up, drawing all the threads of the evidence together by the advocates to summarise their case, their final case that's come out of the questioning and examination of the evidence at the inquiry. It would certainly assist me if those closing submissions, gentlemen, could be available in writing to me. So I've got that in front of me as you're delivering it. Please also, if possible, can you reference in your closings, ideally with footnotes? So if you're referring to a particular piece of evidence, can you say where that evidence, where you're drawing that evidence from, whether it's from particular proof or it may have been in cross-examination or whatever. But if you can reference your evidence, please. Now, if there's to be any application for costs, I'll hear them before the close of the inquiry. Now, to assist me, I would like the application available in writing, and to save time for the other party to have seen the application to enable them to formulate a response, which I then expect to be available to me in writing. Just in terms of programming, is it, at this stage, is anyone intending to make an application for costs? No, no. I appreciate you. You want to reserve your position depending on what happens in the inquiry. That's helpful. Thank you. We then normally make arrangements for a site visit. Now, I requested the production of a proposed route for the site visit. I think the council were going to lead on that in consultation with the appellant. Has that happened, Ms. Moulton? Okay. Well, I don't need it now. So if you could work on that before I actually need to carry out the site visit, that would be helpful. Thank you. Now, if third parties have any requests for viewpoints, perhaps I could ask the council to coordinate the site visit. So if there's anywhere that you particularly want me to see it from, that might be a viewpoint in the landscape, or I know there was I've been requested to go and see the junction, the main road junction. And if there's anywhere else, even if it's somebody's property, if it's got relevance, then if you speak to Miss Moulton in an adjournment, and she can take the details of that. At this stage, I don't know when the site visit will be. I'd anticipated it, if it runs to 4 days, I'd anticipated Friday morning. Alternatively, if we're making good progress, it could be Thursday morning. But if you're not going to be able to stay for the duration, then if you could give Miss Moulton your contact details, so that if you did want me to see it from your property, we'd be able to tell you when I'd be coming. Now, I must stress at the site visit, there's no opportunity to submit further additional evidence or to make additional comments or observations. The purpose of the site visit is purely for me to see the physical features and facts of the appeal site. I did visit yesterday and viewed the site from the public highway. So I've got a general view of the area, an understanding of the area. Obviously I didn't go onto the site, so I don't know the specifics of the layout, etc. But I have got a generality for it. Now I'm going to do as much of the site visit as possible unaccompanied. I appreciate, obviously going onto the site, I will need to be accompanied. But once I know what viewpoints are being requested, I can make more of a decision on how much I need to be accompanied or not. Now, once I have, once we've sorted the site visits arrangements, I would then close the inquiry. I want to talk about just briefly about plans. I think rather than take up inquiry time now, what I'd like to do is go through the plans with the main parties at an adjournment. That's probably easiest. There's not that many plans, so it won't take very long. I just want to make sure I have the plans. Now, I would say that a comment really, that having viewed the appeal site yesterday from the highway, there does seem to be some significant differences between what's on the on the appeal site and what is on the site layout plan. And we're going to come back to that. But I think I do have to make it clear that I'm charged with determining the proposal which the council considered and refused in this case. And I believe that was on the basis of the submitted plans and details. Is that right, Ms. Moulton? Yes. So in the fact that they may differ, the plans may differ from what's actually on site, you have considered it on the basis of the plans. Yes. And I similarly am charged to give that the same consideration. Now, I'm moving on now to the timetabling. So I'll take the written evidence as read, with only summaries or selected extracts being read, although questions can obviously be asked on the full evidence. So with that in mind, what I'd like from the parties is an estimate of timings. I think, Mr. Smythe, you had provided something, yes. So perhaps I can start with the council.
Yes, well,
That's right.
opening 5 minutes.
Yeah.
Evidence in chief up to 20 minutes. Cross-examination of Mr. Brown about an hour. I'm not sure what I said earlier.
Mm-hmm.
And the lay witnesses say up to 15 minutes each, and closing up to half an hour.
Okay. And Mr. Villas.
Apologies for not having provided you anything.
That's right.
But opening about 5 minutes. Cross-examination of I've gone from the outside an hour and a half.
Okay.
But shouldn't get into that. Taking the 4 labels through the reference. Each individual, some of them may take less than others, but about an hour for each.
Okay.
But it may be that things speed up, slow down, depending on who we're talking to. And then for Mr. Brown, no more appearance, say about the summary, and no taking his evidence as read. I'll be asking him about the main Moulton's evidence. So, notwithstanding that, an hour and a half outside. For closing, 3/4 of an hour. That's
Mm-hmm. Okay, thank you. Okay, so I think on that basis, we should be able to hear from Mr. Mannering this morning, and Mr. Brown's initial session.
I just make a comment about that. We're not averse to that approach, and it may be that it's a sensible approach in order to that the third parties understand exactly what the appellant's case is on that. And you know that we've effectively focused on the council's
Yes,
position.
I appreciate that. Yes,
but what I want to avoid is duplication when it comes to Mr. Brown's evidence second time around. So I won't be asking him about any of those points when he gives his main evidence, if that's okay. And the other thing to say is that there was some discussion about representations, and that might include a representation from Mr. Mannering.
mm-hmm.
But I don't think they were. I couldn't find them on the council's website, and Mr. Brown doesn't remember receiving them. So
from Mr. Mannering?
No, from whoever it was that was meant to be distributing them to the parties. So it may be that planning inspectorates sent them through, or ought to have sent them through.
Okay.
But I haven't seen any representations for the purposes of this appeal. I've seen the officer's report, which refers to 223 objections. And I know that those are summarised.
Yes, they're summarised, aren't
And
they?
it may be that the representations repeat those points. But
Okay, well, I mean,
I think
I have a bundle.
it'd be great
and-
if I could at some
Yeah,
point
and-
maybe have a look at those just
Yes.
to make sure there's nothing in them that I ought to be addressing at some later stage.
I mean, my understanding, these were all sent through.
Yeah, I understand.
Okay. Do you have Mr. Mannering's? That's
No. I mean, we're going to hear from
Right.
Mr. Mannering.
No, I appreciate that.
but-
Yes.
but-
Okay. All right. Well, I'm surprised you haven't got
Yeah,
them.
exactly. Yeah. Well,
Do you have them, Miss Moulton?
My understanding was that they were forwarded by the planning inspectorate to all parties,
Yes.
but they are on the live library. Well,
Oh, they are. They're
Mannering-
on the inquiry library as
On
well.
the-
So
on the inquiry
that's another
library.
source for you
Okay,
to draw
yeah.
upon.
I was
Um,
looking at the list, and I didn't readily see that there was a reference to them, but they're on the library. Then I don't need to look at your bundle, Matt.
No, thank you. No. Yeah, so if you go onto the library, you'll be able to see
Yeah,
those. But the
thank you.
important one, obviously, is Mr. Mannering.
Yes.
So I may have to. I appreciate probably Mr. Mannering is going to read it.
He's going to read it.
Are you happy with that?
Yes,
or
I am,
I can
yeah.
pause and let you have a.
If we need 5 minutes, then
Yes, we maybe we just pause
Yeah.
when we get to before Mr. Mannering
Yeah.
gives his statement, so you can just have a quick look.
certainly.
Yeah.
I mean, the other thing is, Madam, you may be about to talk about documents, but I have certainly one letter from a school, a special school, which has come in late, which I'd like to distribute. But
Okay,
I wanted to check that you had the other supporting
I'm going to run through
documents.
those.
Yeah,
So just
sorry.
hold that thought.
Sure.
Okay. Right. So anyway, so we're going to hear from the interested parties, but then we're going to hear from Mr. Brown's going to take the seat so that Mr. Mannering can ask him any questions he wishes to. I may have questions as well on matters outside of the council's case. So I would anticipate that's probably going to be the morning. Probably would be able to start on the council's case probably after an early lunch. Yes. And then hopefully we could hopefully complete Miss Moulton today. What are we thinking? Yes, and then move on to the appellant's case tomorrow, which would obviously, that will suit Mrs. Wilson. Yes, yeah. And do you know what sort of time? You said there were issues around childcare, so what time? Okay, perhaps you could do, would you? Yeah, lovely, thank you. I mean, she's down as number 3, but if necessary, presumably you could change the order and then she could give her evidence first and then be free to do whatever she needs to. Yeah, yeah, that's good. Okay, thank you. Right. Now, in the interest of keeping to the timings you've given to me, I am looking to the witnesses to assist me in my understanding of the case. That's the whole purpose of the expert witness, to help me understand the cases of that they're representing. One particular point is lengthy question evasion doesn't help me at all. So if you're asked a yes or a no question, please answer it, and I'll always make sure that you get the opportunity to explain why you've said yes or no. All right? Good, thank you. Just one point, Mr. Smythe. When if we have interested parties who want to ask questions, if it is a question that you will be asking, please will you let me know? Yeah, thank you. Now I'm going to move on to the documents. So these are proofs. I've got a proof, so a proof summary and appendix 4 to 11 for Elaine Moulton. Is that right? Should I have hang on, is there another one? Oh no, I've got 1 to 4. No, I have. So I know about 4 to 11. Yes, 1 to 11. Then I have for the appellants, I have a proof and a combined appendices 1 to 6 for Philip Brown. And that includes statements of Dawn Wilson, Dolphus Clay, Thomas Clay, and Mark Lee. I also have a statement of common ground dated the 26th of October 2021. which is signed, and a position statement dated the 8th of November 2021. Although my copy isn't signed by the appellant. So is that an agreed copy, Mr. Brown? It's the one dated the 8th of November 2021. My copy isn't, but you're accepting of it. That's fine then. Yeah, if I can just make a note that Mr. Brown's indicated that he's happy with it. Okay, thank you. Right, hang on now. Okay. Now, in addition to the statements from the appellants, I also have a letter from the Napley Lodge Farm Day Nursery. Yep. I have a letter from a private tutor, Mrs. Lynn Jones, and I have a letter from Caroline Escott, who's the Gypsy Romney Travel Advisory Teacher. So are they the letters that you're referring to, Ms. Villas, or is there another one? Okay. Yep. Mm-hmm.
And if I can get that photocopy, it's a very short,
yep.
letter.
Okay. Okay. Well, that will be inquiry document number 1. Okay, just so you know.
Signed copies of the proofs of evidence, should you require, which we thought we would introduce as we can have them photocopied.
What are they? The proofs I've already got?
Yes,
yes, you don't need to trouble yourselves with those. Thank you. Thank you. So the only difference would be they've been signed. Yes. Is that it? Yes. Yeah. Don't worry about that. If they're the ones that you submitted at the due date, yeah, then I'm happy to accept those. Thank you. Just on that letter, Mr. Villas, if when you get it copied, could you let Mr. Smythe see it first, and then I'll once Mr. Smythe's seen it, if he's happy for me to accept it, then I will take it. Thank you. All right, so that's all the documents. Now, is there any other documents that need to come in? I like to have them all at once rather than people pull them out of like a rabbit out of a hat, don't they? And
yeah, there's one document from us. You'll note that in Miss Moulton's proof of evidence, she refers to 2 appeal decisions. And the first one in respect of Station Road came out on the 5th of November. It's your colleague, Inspector McClone, in this borough Greenbelt case, and a temporary consent for 4 years was granted. I think it was sent to your case officer. It may not have reached you, but
yeah,
I've got hard
it hasn't
copies.
reached me. So if you have a copy of that,
and
please.
do you want a hard copy as well?
Yes, please. Yeah, thank you. And that will be inquiry document number 2.
Yeah.
Thank you very much. Okay, don't worry. Yep.
Which I read last night, not having bought case authorities, but I realised that Mr. Brown had included a reference to 3 or 4. I mean, they're very familiar cases, but nevertheless, we haven't provided you with the actual cases themselves. I don't have the facility to do any more than email them.
Okay.
But I can do that. I can email them to the council should you need to take them away.
Which particular ones?
So there was the Julie Brown case, the special order case. They're all okay. Pretty much bolded in emphasis in Mr. Brown's.
It's always helpful, actually, if you refer to it in a proof of evidence, you actually provide it. That's supposed to be part of your evidence, anyway.
Mr. Brown, having worked within the past and finding that I usually turn up that whole folder, which sometimes I present to the inspector, who then says I've already got that for this. Yeah. Last time. And other times my opponents object when I produce such a large folder.
Okay.
On this occasion, I see that you asked for it. It's probably
no.
one way or another, we can get those authorities to, if you're preferring to be electronic, then we can do that. Probably we can arrange.
Okay, perhaps could I prevail on the council? If they're emailed to the council, could they get them printed off for me, please? Thank you. There we go. Yes, thank you. I do have a copy of, if it's one of Smith versus Secretary of State for Housing, Communities and Local Government, I've got a copy of that.
Is that the most recent Smith?
17th of June 2021. Lisa Smith. Sorry?
It's about the definition.
Yes, it is.
Yes,
I have a
okay.
copy of that.
Yeah.
Yeah. Right, okay. Right, so going to move on then to the main issues. My preliminary view of the main issues are the effect of the proposal on the character and openness of the countryside, with particular regard to the impact on the enclosure of the appeal site, whether the proposed location of the Gypsy Caravan site would represent a suitable location in respect of accessibility for pedestrians and offers a real choice to residents in respect of sustainable modes of transport, and whether any identified harms would be outweighed by other considerations, including the general need for and provision of sites, the availability of alternatives, and the personal circumstances of the appellants and their families, so as to justify the development. Would you like me to go through those again, gentlemen? Are you all right? No? Okay. Now, I appreciate that there may be other matters which are particularly concerning interested parties, and those will come out during this morning's session. Now, before we move on, are there any other questions about the procedure? Has anybody got any questions about procedure? No? Okay, thank you. So I'm going to hear from the council first, their opening remarks to clarify their position and the basis of their case. So, Mr. Smythe, thank you.
Well, the council's opening, the reprehensible manner in which the site was established. Whilst the planning system allows retrospective planning applications, recently the government changed the guidance so that decision makers can take into account the manner in which the breach of planning control arises. Here, the establishment of the Gypsy Traveller site was plainly calculated and well planned. Whilst in the past, this conduct would have been immaterial, it is now a material consideration which weighs against the appeal. The High Court was sufficiently concerned about the risk that even more work be undertaken to expand and entrench the site, that it grants an injunction to hold the ring and to prevent further breaches. Where does that leave us? The manner in which the site was established and the unattractive track record of compliance reflects very poorly on the appellants. The council doubts that the appellants will offer any apology for their conduct. Defiance will probably be the order of the day. This conduct detracts from the credibility of the appellants and the other site occupiers, and also means, ma'am, that you can have little confidence that any conditions attached to a planning permission intended to mitigate a harmful impact will in fact be complied with. I turn finally to the council's case. The council will not call evidence in support of its second and third reasons for refusal. These were properly made at the time of the decision, but since then, additional information has been forthcoming to address the concerns articulated. In respect to the second reason for refusal, which is highway safety, a topographical survey and swept path analysis were provided by the appellants. This was scrutinised by the Highway Authority, who decided that it was acceptable and meant that, forgive me, sorry, decided that it was acceptable and meant that its concern could be satisfactorily addressed by means of condition. In respect of the third reason for refusal, which relates to drainage, a groundwater source protection zone assessment was provided by the appellants. This was interrogated by the water undertaker, which is Severn Trent Water, who decided that it was acceptable and meant that its concern could be satisfactorily addressed by way of condition. Conditions have been agreed between the parties, which means that these two reasons for refusal fall away. There's nothing especially unusual about this occurrence. It is common for the issues to be narrowed during the course of the appeal process. Notwithstanding that the council cannot demonstrate a 5-year supply of pitches in the borough, it remains firmly of the view that the site is an unacceptable location for residential development. Had the appellants liaised with the council prior to establishing the unauthorised site, they would have realised that it occupies a sensitive location in the local landscape. The site enjoys protection under a local planning landscape designation, the area of landscape enhancement. The unauthorised development causes significant harm to the character and appearance of the area. The 2-metre high acoustic fence, in particular, is a conspicuous and incongruent feature. In addition, whilst its rural location is not unacceptable as a matter of principle, in this case, the site is marooned off the A53, such that its occupants will inevitably be dependent upon the private car. There's no realistic public transport option for the site whatsoever, given the dangerous walk route along the A53, which is unlit and lacks a pedestrian walkway. This serious deficiency renders the site unsustainable, notwithstanding the benefits which properly weigh in favour of the appeal. In due course, ma'am, you'll be invited to dismiss the appeal.
Thank you, Madam. I'm not going to provide you with a copy. No, I'm doing it. No, I won't, Madam. And unfortunately, it covers much of the issues that have already been discussed by your good self in opening the inquiry. You've identified the main issues in this appeal, and clearly we need to hear from the experts as to their views, but ultimately it'll be a decision for you as to the impact of the development on the appearance of the surrounding countryside. And when determining that issue, we would invite you to apply a test of acceptability, as Mr. Brown suggests in his proof of evidence. When it comes to the other main issue, sustainability, we will invite you to adopt the approach taken by one of your fellow inspectors, Jean Russell, in the Willow Park case, and apply a realistic yardstick, as it were, to the question of whether or not there's a requirement, and you won't find it in the policy upon which the local authority relies, but whether there is in fact a requirement that there be safe pedestrian access to a public transport as such as there is, that being the bus stops a few hundred metres away from the site. We'll invite you to conclude that there isn't any significant conflict with the development plan, and that in the circumstances ask you to apply the presumption in favour of sustainable development and grant planning permission. But if you conclude against us that there is some significant harm arising from the development, then we'll be inviting you to look at the material considerations which, when taken individually or together, clearly we would say, but certainly outweigh that harm which has been identified, and that will include the national, regional and local need for gypsy site provision, the adequacy of the development plan policy, and the fact that there is no 5-year supply of developable sites, points which are agreed, the personal needs of the site residents for a gypsy site, the lack of availability of alternative site provision, the personal circumstances of the site residents, which are a separate factor from their need for a site, and then finally the human rights of those living on the site, and particularly the best interests of their children. And in weighing those against the harm that may have been found to arise from the developments, we would invite you to conclude that in this case, permanent permission ought to be granted, or failing that, at least temporary planning permission, subject, of course, to conditions which we would invite you to conclude can in fact be imposed with the knowledge that they will be satisfied. Thank you.
I'm just going to pause for 5 minutes just to give the appellant the opportunity to have a look at Mr. Mannering's statement in the inquiry library. So, Mr. Mannering, if you wouldn't mind coming and sitting up at the table, and we'll start. If you start your statement, we'll just a bit longer than 5 minutes at 5 to 11. All right. We're just going to have a little adjournment, and then if you could be in the hot seat at 5 to 11, please. All right, good, thank you. In the meantime, if you can have a read of his statement, please. Thank you. Miss Mannering, do you want to come and take a seat, please? Thank you. We'll just pause because we're missing an advocate now. So I have been roundly chastised because I once or twice forgot to put the microphone back on. So my apologies. I will try and remember to put the microphone on when we speak, because obviously if you get one with the live streaming, then they can't hear. Right. Mr. Villas, are you satisfied you've had a chance to have a look at Mr. Mannering's? Oh, great. Okay. Okay. Well, Mr. Mannering's going to read it out anyway now. So at least you've got it in front of you, which is something. Right. Okay. Mr. Mannering, would you like to make your statement then, please?
I have actually made some additions to
That's
the
fine.
statement
That's
since
fine.
I submitted it. I hope you'll accept my additional matters.
Absolutely. I've got a copy of the statement you sent in, so I'll annotate it as I'm going through if you make additions.
Okay, yeah,
All right?
sorry, I have altered it, but
No, that's fine. Off
that's
you go.
okay.
Thank
Yeah,
you.
fine. Okay, good morning. Yeah, sorry, no, I'm fine. I'm actually better standing up. Thank you. Okay. My name is Andrew Mannering. I'm 75 years old and have lived with my wife, Sarah, who is 70, in our own house in Blackbrook. We've been living there for over 40 years. I'm a retired gas engineering manager, and I sit on Mayor and Aston Parish Council. And I sat on the steering group who drafted and put together the Chorlton, Mayor and Aston and Whitmore Neighbourhood Development Plan. I like to consider myself as a law-abiding citizen, and I'd like to bring before you, or before this hearing, matters which I believe are important and critical in determining the result of the appeal. I hope that I will have covered most of the major points in a straightforward and unbiased manner. The matters which I'm going to be talking about are unintentional authorised development, human rights, local residents, planning regulations, court order of June 2020. I'll be talking about children, danger to children, and possibly inspectors visiting the site, unsuitability of the site, the Severn Trent Water groundwater sustainability, Severn Trent Water groundwater protection, and I should be talking about the existing cesspit. Okay. It is now government planning policy that intentional authorised development is a material consideration that should be weighted in the determination of planning applications and appeals. The illegal occupation and change in use of the land was done in the knowledge that planning permission had not been granted. The appellant's agent, Mr. Philip Brown, states that if the appeal fails, it is likely that the families would have to leave the appeal site and take up a roadside existence. This would result in an interference with their human rights with regard to Article 8 of the European Convention for Human Rights. The appellants were well aware of their illegal actions could have resulted in them being refused permission, and that their resulting existence would be in jeopardy, but of their own doing. I believe they came from a stable site in Cheshire and were not homeless. The 230 or so residents that wrote into the council objecting to the planning application were informed that their objections should be restricted to planning matters alone. It is evident that the appellants and their agent have used all sorts of emotive issues to highlight and prioritise their personal circumstances and health issues. Many law-abiding residents in the locality have personal feelings, needs, emotive issues, and health conditions which were forbidden from being brought to the attention of the planners and the inspector. The appellant's agent appears to have twisted and manipulated every planning regulation to his own advantage and has been able to advise his clients to make statements and resultant actions and make the application appear plausible, feasible, and a fait accompli. Examples of these are as follows. The appellant's agent states that the proposed development would, as required by policy, minimise any negative impacts on the local landscape. Clearly, this is incorrect. Previously, the site was a green field in open countryside. The proposed caravan site would replace the existing built development of a glass house and shed within the area of the field. The built development previously on the site has never been removed, and the shed and greenhouse are still there. In terms of core strategy policy CSP7, the appellant's agent states that the proposed development would not have an unacceptable impact on the character or appearance of the countryside and is capable of being satisfactorily assimilated into its landscape setting and to minimise the visual impact of the site when viewed from the A51 and A53. The caravans and mobile homes will be orientated to present their end elevations towards the north and south. This is incorrect as they currently face east-west. Great emphasis has been put on tree planting, helping to merge the development into the woodland area, thus minimising any negative impacts on the local landscape. The caravan and mobile home site has been enclosed by a closed-boarded wooden fence, giving the impression of a private, isolated enclave. Even if the upper parts of the mobile homes remained visible, according to the appellant's agent, they would be viewed against the solid barrier of the hillside and woodland of Mare Hills. This would help to mitigate any sense of intrusion of the development into the surrounding landscape. Furthermore, because of the volume and noise of traffic travelling along Newcastle Road, there is not the sense that the development is intruding into a landscape of tranquil rural character. This site is a massive intrusion on the rural landscape, and may I suggest you visit the site at night when all the mobile homes have their outside lights switched on. Even if, in the view of the appellant's agent, development would fully comply with core strategy policy CSP7 and that planning permission should be granted, material considerations indicate otherwise. There is insufficient weight to overcome the refusal of planning permission. None of this changes the fact that the planning application for this development was submitted the day before work started at 5 o'clock in the morning, and that the site was fully occupied over a bank holiday weekend when council officials were not available to stop them. This was testament to the fact that the appellants knew exactly what they were doing and that they were evading the fact that they did not have permission and that their operations and occupation were unlawful. The court order dated the 22nd of June 2020, obtained by Newcastle under Lyme, states that you must not bring any caravan or mobile home onto this land. The defendants were forbidden from stationing any more caravans, mobile homes on the land, erecting any structure, building, importing or depositing any material, including hardcore, or excavating or digging up the land. For the avoidance of doubt, if a caravan was removed from the land, it could not be replaced with a different one. Since the court order, site works have taken place and 2 mobile homes were positioned or sited on Saturday, the 17th of July, 2021, in place of touring caravans. Surely this is a contempt of court. Information provided suggests that there are 10 children on site and that 7 of them are of school age. There will come a time when some or all of these children will need to use public transport to ride to school and back. The appellant's agent states that the site is appropriate for a gypsy site in principle and that site is conveniently situated for access to public transport. Bus stops are sited on the A51 some distance from the site, and access would necessitate walking along an unrestricted road with no pavements or street lighting. I would recommend the inspector visit the site during the hours of darkness to make your own assessment. I cannot stress too strongly the dangers to children when walking this route in the dark, and would suggest that the inspector catches the bus from Newcastle Town Bus Centre bus station, leaving at 4:30 and arriving at Blackbrook at 10 minutes to 5. And I will be happy to assist and escort you if you prefer, if you'd like to do that. This site at Blackbrook is totally unsuitable for any residential development. This should also include a possible transient collection of caravans and mobile homes, and their mobility does not mean that they are not residential. Due to the presence and depth of the underlying aquifer, it is essential that foul water be removed through a positive connection to a sewer. As the nearest main sewers are at Mare and Ashley, a considerable distance away, there is little chance of a suitable connection, and it is unlikely and almost impossible. Severn Trent Water have highlighted the potential of this development to compromise their ability to provide sustainable sources of groundwater. Without adequate mitigation measures, the development poses high potential risks to groundwater quality, which is near a strategically important public water supply at the Wellings borehole pumping station, which is just across the road from the site. There is high potential contamination risk and resultant impacts from the loss of public water supply. The Wellings supplies almost 60,000 properties, and any loss of supply from this pumping station caused by contamination could have considerable impacts on Severn Trent's assets and infrastructure, including its ability to supply water to customers. The cost of such impacts would be considerable, and who would pay for them? The appeal documents do not capture the conclusion and recommendation of the assessment report, and therefore they appear inconsistent with each other. Severn Trent Water disagree that the risk is minimal, and it is not clear if the groundwater source protection zone assessment findings commissioned by the appellant have been fully understood. Mitigation for the foul drainage and hard standing has not been provided, and Severn Trent Water need clarification that the measures as proposed in the groundwater source protection zone assessment will be provided. They are at this stage unable to remove their concerns regarding risks to groundwater quality. Severn Trent Water concur with the conclusion that the hard standing, which actually consists of crushed demolition hardcore overlaid with stone chippings, is likely to become contaminated by persistent pollutants. The hard standing should therefore either be impermeable or permeable and underlaid with an impermeable liner. Drainage or any runoff from the hard standing should be directed to the watercourse via an oil interceptor or subsystem such as a wetland or bioretention feature. All of this should have been carried out before any occupation of the site occurred. And any retrospective groundwork would require close supervision by a regulatory authority. The cesspit, which is currently in use, should be decommissioned and removed as it poses a high risk of potential groundwater contamination. As previously stated, this site is an unsuitable location for any residential development. And despite their unlawful occupation, the appellants have continued to completely ignore the law of the land, and I trust this will be taken into consideration when determining the appeal. I believe that I have the support of the Borough Council and County Council in this matter. Thank you. Thank you.
No, you stay with her. Just, Mr. Villas, do you have any questions?
Madam, no, I have no questions. Thank you.
Thank you, Mr. Mannering.
Okay.
Thank you.
Thank you.
Right, Mr. Brown, do you want to come and sit at the witness table? Mr. Mannering, I'm asking Mr. Brown to come and to the witness table so that you can ask him any questions you might like to. Do you have any questions for him?
My document was a statement only, really.
Right, so you don't actually have any questions for Mr. Brown? No, okay, I have. So, Mr. Brown, do you want to take the seat? Thank you. Right, so Mr. Brown, what I'm interested in is a little bit more information about the issues around the foul sewer, right, or foul drainage, yeah, and surface water drainage. So this isn't a point that the council are pursuing because Severn Trent Water, I think, have put forward these conditions, haven't they? Yes. So they've basically said that the cesspit isn't suitable.
No.
Is that right? And that it's either got to be no. I appreciate that. The planning application form indicated it was going to be a sewage treatment plant. That's right, which obviously hasn't been installed. Is that right?
No, it hasn't. No.
It hasn't. Okay. And so they've suggested the sewage treatment plant or a connection through to there's 2 points, isn't there, of access, which seem to be some distance away, 1.9 kilometres in some instances. So they haven't offered a preference.
It's too far away to,
right, okay. So I was just going to ask, so presumably the appellants don't have access across that land. There's no rights for them to actually install a connection to the main sewer.
No, it would be too far away anyway.
Right, so the main sewer is basically off the table. It's a sewage treatment plant.
Yeah, there are no properties around there that are on main sewer.
No, okay. So can you just perhaps give me a bit more detail about, bearing in mind the initial proposal was for a sewage treatment plant, what the costings for that would be?
I can't give you a detailed costing for that, but they generally speaking are, when it's for 1 or 2 houses, you're looking at probably £3,000–4,000 to install.
I must admit, I'm surprised you can't give me a sort of a more accurate figure in the sense that obviously it must have been something that was taken into consideration.
They vary anyway. And you've got to have some form of sewage treatment or something to deal with foul drainage. So the most basic form is a cess tank. And sorry, can I just stop, Mr. Brown? Can you move your microphone in front of you, just in case people can't hear? Because you're turning. Yeah. Obviously, I appreciate you turning to look at me, but if you can speak into the microphone. Yeah. So the most basic form of treatment would be a cess tank, which is basically a holding tank. They generally will be around £1,000.
But we've
for a
always established
single-
that's not
So
suitable.
that's not suitable.
No.
So then the prices increase from there. So a septic tank, which again wouldn't be suitable on this site, are maybe a couple of £1,000, and packaged sewage treatment plants start at around 3,000. But there are various types available, and they will be at various costs and various efficiencies. But the best packaged sewage treatment plants now are about they can be 89% efficient at removing the toxics out of the
Yes, it's not so much the efficiency of it, because I think Severn Trent Water have accepted that a sewage treatment plant would do the job.
As I was going to point out,
Okay.
89% efficient. Sewage treatment works are around the same figure, around 89–90% efficient. So you are getting the same level of efficiency as mains drainage, basically.
Yeah, I don't doubt that, Mr. Brown. I think what I'm interested in is bearing in mind there's four family units for the treatment plant to serve.
You wouldn't have, you some of these treatment plants, they come in units, and the more units you get, you link them together so that they can serve a bigger population.
Okay, but
some come as a single unit, which can serve a bigger population. Generally, as I've said, they're around £3,000 to £5,000.
oh, it's 5 now. You said 4 to start with, right? 3,000 to 5,000. Okay. Yeah, but you or your clients haven't actually done any research on the capacity that would be required and the figure that will be.
The capacity will depend on the population, and for 4 families, you would normally be looking at something with a capacity of a population of between 15 and 20 persons.
Right. Okay, so it's a very generalised idea of the cost of installing the treatment plant, because you don't have any, you've not produced any evidence on that.
Well, as I said, £3,000 to £5,000.
Okay, well, yeah, all
Because
right.
you're buying the tank, the groundworks. My clients are in a position to do.
Yeah, I understand that.
themselves.
Yes, yeah, okay, I understand that. Right, okay, and then moving on then to the surface water. So Severn Trent are now saying that they would be prepared to accept an impermeable surfacing or a permeable one, but they want an impermeable liner.
There'd be an impermeable
yeah.
liner.
So what's the plan for that? At the moment, it's got crushed.
It has bearing in mind that not all of the site has been developed. So the proposals actually spread over a bigger area than is currently occupied.
Okay.
Because I noticed that Mr. Mainwaring was referring to the existing buildings, the glass houses and storage building still being there. Well, yes, they are. That's because the development that's being applied for is not the same as the development that has taken place so far. So the proposal would be that obviously the existing buildings would be demolished and removed. The ground, the loose material on the ground at the moment would be scraped away. You would normally lay that there is already a membrane down, but you would put an impermeable membrane above the hard standard, crushed hardcore, and then lay your top layer on top of that.
So they've already put one layer down, one membrane down. Is that
There is, but
permeable
it
or
won't be that's not impermeable.
That's not impermeable. Okay. Well, I'll be interested to see that when we go on site. And then the crushed surfacing is on top of that. And what you're now saying is you then put another membrane on top of that.
That's correct, yes.
Which will be impermeable.
Yes.
So this is going to require quite a lot of sort of moving around of mobile homes, etc. Is it?
Well, it would. The layout, the approved layout, or the proposed layout would require that in any event. And the mobile homes haven't been bricked in.
Okay.
And they're not connected to the drainage system. So they're all things that would need to happen anyway.
So are they connected to the cesspit then?
I understand that they are, yes.
They are?
Yeah. And the cess tank is emptied at regular intervals.
Was the cesspit installed when your clients moved on to the site, or was it an existing one?
I can't tell you that, I'm afraid.
Okay, well, I'll ask that of your clients. Thank you. So has any work been done on the cost of the permeable or impermeable, but whichever option it's decided to take?
I haven't got a costing for the actual membrane, but I can't imagine that a membrane would cost very much in any event.
Okay. And you obviously rightly highlighted that the layout plan, the site location plan, the layout doesn't reflect the layout that's on site at the moment.
Correct.
I noticed that there was close boarded fencing around the site. So is that in the place that's shown on the plan, or is that to be moved?
Well, there's no proposal to keep that close boarded fencing. It is in the correct, roughly the correct position for fencing, but the fencing that's proposed on the site layout plan is post and rail fencing.
Well, you've got some acoustic fencing, haven't you?
There's acoustic fencing along the eastern boundary, but only along the eastern boundary. And you'll see that along that eastern boundary, you've also got one of the amenity buildings. So it's not, it's not complete fence.
So the intention is to remove the close boarded fencing and replace it with post and rail.
With post and rail and hedgerow and tree planting.
There's quite a lot of, I noticed quite a lot of conifers have been planted.
They have, but that's not part of a formal landscaping scheme.
Okay.
I think it was an attempt to show what the screening that could be achieved.
Certainly quick growing, but not particularly
well, no,
sympathetic.
I wouldn't expect that to be the permanent solution.
Okay. Right. Can I just ask about the stables and the paddock?
Yeah.
Okay, so the paddock, I believe, that's actually outside of the appeal site, isn't it?
It is, yeah.
At the moment, I think the stables are also outside the appeal site, where they are at the moment.
They are, yes. They were not put in the position that was shown on the site layout plan, but they can be moved, and they would have been moved had it not been for the court order.
So is that the only land that your clients have access to in that location?
well, that's the extent of their land holding, is the area edged red and blue, but they do rent other land in the locality for horses.
Yes, but because I think it was there were two locations mentioned, but they're not in the immediate vicinity of this location.
No.
Okay, and what's the stable? So the stable has 2 loose boxes and a tack room.
Yeah.
So how many horses would that pasture support?
Well, I think what the council is now suggesting through condition is that it shouldn't support more than 1. That doesn't mean to say that you couldn't have more than 1 horse in the stables, of course, because you might want to have a horse in stables that would graze elsewhere, but has to be in a stable temporarily for ill health or for treatment by a vet, something of that nature.
Okay, I think I'll probably ask some more questions on that topic when I speak to your clients. Let me just check my notes. I wanted to ask about what services that the site is actually connected to. I appreciate we've got the cesspit,
Electricity and water.
Right.
Mains
so
electric.
Is it
and
it's on mains electric?
Mains electric and mains water.
So is the generator still in use then? No. Now, the previous use was as a wholesale nursery, is that right? Yeah.
Yes.
And there was mention of the access having been widened. Was
Yes,
that work
that
actually carried
was
out?
part of the planning permission for the wholesale nursery.
Right. So is that, perhaps Miss Moulton, would you know that work was carried out, was it, to the access?
Yes, to my knowledge, the works were shown on the approved plans for the nursery use was undertaken at the time the permission was implemented.
So would the previous use as a nursery, that would indicate that they had larger vehicles visiting the site, is that correct?
Yes, not only that, at the time, at the time of the first application, they'd estimated that the nursery business would have generated employment for between 1 and 3 people, and that there was no living accommodation on site. So those 3 people would have to travel to the site daily. Deliveries to the site would have been by large vehicles. And
When you say they, who are they?
sorry.
You said they estimated, so who are they?
I presume it was the council that were accepting that was the case.
So I was just trying to ask Miss Moulton. Miss Moulton, is that correct?
I'd need to check the records for that particular application. I've no reason to think it's not correct, but I can't confirm it as such at this moment.
So, Mr. Brown, where does it say that? So it saves Miss Moulton a job having to search through applications. You obviously got that. You've already researched that, so you know where it is.
If I can go and get my phone.
Yes, do. Yes, please.
So this was an assessment made by previous planning consultant, which is Alison Heine. So it was done for the planning application 19/00332/FUL. So it was her assessment.
Okay. Miss Moulton, can I leave you to check that? And then you come back and let me know if you agree with that. Thank you. But just to say, it was a wholesale operation, so they would have had some deliveries, but then presumably there was deliveries to the site, but also then taking goods out.
Because it was wholesale, you would expect them to goods to be taken out by larger vehicles as well, commercial vehicles.
Okay. So just thinking about the highways, the Highway Authority, their main concern was visibility, really, wasn't it? The visibility displays.
Yes.
So I think it's correct that's been resolved. That you've been able to show that the required visibility displays from the Highway Authority can be provided. Is that right?
That's correct, and it's based on topographical survey.
Okay, thank you. Mr. Mannering, has that thrown up anything for you that you'd like to ask?
No, I can't think of any.
No. Okay, that's fine. Okay, thank you very much. Right, thanks very much, Mr. Brown. Oh, yes, do. Yes, of course you can.
Ether, as it were. Can I just ask a couple of questions of Mr. Brown? The first is, there's been talk of a cess pit from the inspector and a cess tank from you. Is there a difference, and if so, what is on site? Is it a cess pit or a tank?
It will be a cess tank. Well, there's no difference.
No,
Okay, there
the
is no
same
difference.
thing, yeah.
Yeah, okay. We're not talking about something which just drains away outside of a tank.
No. It's a sealed, closed tank that has to be pumped out. It's a holding tank.
Thank you. And I think as far as landscaping is concerned, you were asked about conifers, but I'll ask questions about landscaping when we come to Mr. Brown's evidence. And that may be just to assist everybody, including Elaine Moulton. The reference to Alison Heiner's work on the previous application, was that recorded in the officer's report, or is it in a document that went with the application that
It's
you've
a
seen?
document that went with the application.
Okay.
It's a design and access statement.
Oh, it's a design. Okay. Thank you very much. That's helpful. That might speed things up. Thank you very much.
Spillers, and thank you, Mr. Brown. Right, that completes the session for interested parties, unless there's anybody else who wants to say anything. No? Okay, thank you. Okay, so we're going to move on to the case for the council now. Where's my time has gone? Right, well, I think we could make a start before lunch. So you thought 20 minutes, didn't you, for evidence-ish? Yeah. So we'll just pause briefly and let Miss Moulton move into the witness seat, and then we'll hear from the council's evidence in chief, please. Okay. Right, Mr. Smythe, thank you. Can you introduce your witness?
Yes, can I introduce Mrs. Moulton to the, yes, it was my, Miss, yeah. If I can introduce Mrs. Moulton to the inquiry, you hold a Bachelor of Arts degree in Town and Country Planning, and you're a chartered member of the Royal Town and Planning Institute, is that right?
Yes, that's correct.
And you currently hold the post of Development Management Business Manager for the Borough Council.
Yes.
And you've held that position for a period of time.
I have, yes.
Have you got your proof of evidence in front of you?
I do.
And you adopt that as your evidence to this inquiry?
I do.
Excellent. Ma'am, it's not my practice to invite a witness to read any parts of it, but just to pick up on some of the points in it. Firstly, can we take up page 3, paragraph 4.4? Yes, forgive me, yes. Is there anything you'd like to clarify about this paragraph?
Yes, I think it's fair to say that prior to the replacing of the touring caravans with the mobile homes on the site, that's been referred to by Mr. Mannering, the appellants did approach the council. 2 of the families did approach the council, one directly, one via a liaison person from the county council. The indication was that there was a need to provide a mobile home on the site because caring for children with particular medical conditions was proving difficult in the touring caravans. The response that was given by the council was that there was no objections to that, but the court order was highlighted, and the indication was that would be at their own risk. So I just wanted to make it clear that we were aware of that. It was a month later after the correspondence that the mobile homes were moved onto the site, but the council was aware of it in advance.
Could you just clarify that for me again? So how many mobile homes were on there when the court order came in?
2.
And so you're talking now about a third one that was brought in after the court order was put in place, but the appellants had contacted you or contact the council just to let them know and the reasons why they were going to introduce the third one. Is that correct?
A third and a fourth.
And a fourth, so two additional ones. Okay. Right, so you said that the reasoning was that they needed a mobile home on the site for the needs of a particular child. So that's
in 2 of the families, yes.
Two of the families, okay.
I don't recall the precise reasons, but they were both indicating particular difficulties in caring for children.
Okay, thank you.
Yeah.
Madam, forgive me, we do have the email, which I was going to put to Mrs. Moulton, but it wasn't a question of just informing the council, it was a question of asking permission, and permission was granted, but at their own risk, on the basis that subsequently permission might be refused or the court might vary the order.
That was a slip of my tongue.
Yeah,
I got it was requesting.
We can
get
certainly make sure the email is produced.
Yes, thank you.
And the play equipment, would it help if we took up the injunction? Is it your appendix 6? And it's paragraph 1 of the order. The defendants are forbidden from erecting any structural building. And was there any just was there any application made to the council about the play equipment?
No, we weren't made aware of the play equipment being brought onto the site. We observed that on site visits. The stable block was also brought onto the site without us being made aware of that, and it has changed locations. It was initially sited on the western boundary, and it's now been moved closer to the where the play equipment is in situ.
So I noticed the area of the injunction, the red-lined area, is a considerably larger area than the planning application site. Is that right?
Yes, it's a combination of the red edged and the blue edged land that forms the application appeal plan.
Yeah, and the play equipment, just to clarify, the play equipment, that's not within the red-lined area of the appeal site. Is that right?
That's correct. It's outside of the appeal site
It's in the
area.
blue land.
It's on the blue edged land. Yes.
Yeah. Okay. Thank you.
The stable block, was that brought on before or after the injunction, as far as you're aware?
After the injunction, as far as I'm aware.
Next is page 5 of your proof, paragraph 511. You draw the inspector's attention to when you at the time of writing 2 anticipated appeal decisions. The first one we've given to the inspector in his inquiry document 1. And are you still expecting a decision in 5 Boggs Cottage?
Yes, well, we have now had a date scheduled for the hearing, and that's due to take place on the 23rd of February 2022. So yes, we do anticipate an appeal decision, but it will be some time away.
Yeah. Next is paragraph 6.8 on page 8. You tell us there, you make reference to the acoustic fence along the south, east and west boundary. Is that correct? And if not, how did you make that mistake?
Yes, upon closer inspection of the site plan, it is apparent that the acoustic fence is proposed just on the eastern boundary. Obviously, there is a fence of possibly around 2 meters in height around 3 of the boundaries to the compound, to the area upon which the caravans are located. And yes, the plan was unclear until closer inspection was given of that. So yes, I can clarify that the acoustic fence as proposed is only on the eastern boundary.
Sorry, what's the difference between the acoustic fence and I think it's close boarded, isn't it?
There is a specification for the acoustic fence within the application documents. As it may be that the close boarded fence is adequate for that purpose, but my understanding is that it will be replaced with something that has a certain density and no holes, no gaps, and nothing to allow noise in or out.
So the acoustic fence that's referred to on the site layout plan, is that the fence that's on the eastern boundary, or is it that, because you said there's a specification for it, so
the proposal is to place an acoustic fence on that eastern boundary to the specification set out within the noise assessment that form part of the application. I can't confirm whether the fence that is on site now is to that specification.
Okay, so basically you're acknowledging that the site plan shows the intention to erect an acoustic fence, which should be in accordance with the specification in the noise assessment, but that the fence that's there at the moment, you don't know whether that's an acoustic fence or not.
No, I can't clarify whether the fence is to the specification, and I can clarify that it's on more boundaries than the requirement for the acoustic fence as within the proposal.
Of your evidence, you've appended the bus timetables at, I think it's Appendix 9 of your proof. Could you take that up?
Yes.
Firstly, have you had the opportunity to read the appellant's evidence?
I have, yes.
And does any of the appellant's witnesses make any assertion that they've used the buses in the past?
No, there's no reference to use of the bus service. The two bus services that are referred to within my Appendix 9.
And looking at the Appendix 9, the inspector may have read it, but is there anything you want to flag up as to the quality of the and frequency of the bus services given the rural location?
Well, there is an hourly service for most of the day prior to 8 o'clock. It would appear that there are two services, well, two buses running between 7 and 8 coming from Shrewsbury, and in the opposite direction, I think that there are possibly 3 going from the Hanley bus station out towards Market Drayton. But during the day, it's an hourly service.
Can we just look at that again? So it's an hourly service. Is it that the buses only go from Shrewsbury to Market Drayton and back again? That's the only route, or?
It's between Shrewsbury, well, the 64 service, it's between Shrewsbury bus service and Hanley bus service, passing the site, going through Market Drayton, Loggerheads, and past the site to the bus stops on the A51. So, yes.
Okay. So what's the latest bus that you could get to come back of an evening, either from Shrewsbury or Market Drayton?
Coming from Shrewsbury, with the starting point being Shrewsbury bus station, it is 6:15. Closer to the site, it's more like possibly about 7 o'clock, and it's a similar time in the other direction. So yeah, the last service is around 7 o'clock.
Anything else you want to say about bus services, Ms. Moulton?
Nothing particular. I mean, as in rural areas, that it's not a bad service, but obviously it is limited in its frequency.
Yeah. And then finally, there's 2 points we want to deal with in respect to Mr. Brown's proof. Firstly, can we turn to Mr. Brown's paragraph 5.20?
Yes.
And it's over the page, so towards the end of the paragraph, where Mr. Brown makes reference to proposed junction improvements on the A51, A53 as part of the second phase of HS2. So it appears to be that Mr. Brown is placing some weight on the fact that the junction may improve in the future. What's your response to that?
Well, I have looked at the plan that forms part of the appendices to Mr. Brown's proof of evidence. I don't see that there is any improvement from a pedestrian point of view. The proposal is to divert the A53 and form a new junction with the A51, and that will be the route for the main traffic. And there's no indication that there'll be a footpath created along that route. The existing route will be retained as a vehicular route, but serving the compound that is to be formed at that junction, the existing junction, which is a compound associated with the construction of the HS2 development. So there will still be vehicles travelling along the existing route up to the point where it joins moves into the compound, which is very close to the existing junction with the A51. So there won't be a safe pedestrian route during the construction phase of the HS2. There will be a new route, but both routes that a pedestrian could travel along will have heavy vehicles and lots of vehicles, and there's no footpath proposed. At the end of the HS2 development, when the compound is decommissioned, no reason to think that the former route will be retained for purposes of gaining access to properties, given that there is a spur shown on the plan to serve the properties at the junction, and there's no basis upon which I would anticipate that the highway would be retained. It would serve no purpose. I would anticipate that the land will be given over to the landowner, who have had to give up land to form the new access and to site the compound, so it will become land associated with the other uses. So there is no improvement in terms of the pedestrian link because there's no footpath provided.
Your response presupposes that we take what's shown in the appendix at face value. Given the government's announcement about HS2 last week, what confidence can the inspector have that what is proposed on paper is actually going to be delivered any time in the foreseeable future?
Well, as far as I'm aware, there is no timetable setting out when such works will be carried out, and there is an indication that the plans on the final plans that it is subject to design amendment potentially. So yes, there's no guarantee that those works will be done.
And final point to canvass with you, Ma'am, I'll do this fairly briskly. It's to do about how robust the GTAA is. I say that because on any reading, there's a significant shortfall. I'm not sure to what extent it will assist you to decipher exactly what the shortfall is. But as Mr. Brown has criticised the GTAA, I will deal with it with Mrs. Moulton.
I don't want to get into a detailed analysis of the GTAA with opposing positions. I think that the statement of common ground or position statement, there seemed to be an agreement that there was a shortfall. I appreciate that I think it was the appellant said that the calculation, that they had questioned the calculation of the shortfall, but there's no disagreement that there is a shortfall. So unless you want to expand on your positions, I don't want it to turn into some sort of analytical exercise.
Can I just indicate from my learned friend's benefit that although Mr. Brown's got a lot he'd like to say about the GTAAs, and we've said it before in other inquiries on similar basis, I was hoping to hold him back from that, given what you said in the pre-inquiry meeting and the level of agreement. And you've got what Mr. Brown says in glorious technicolor in his proof. And I don't, so I wasn't intending to ask Mrs. Moulton much, if anything, about need other than what's agreed. But having said that, and I don't, it's not a threat, but I mean, obviously if Mrs. Moulton says anything else, then I may have to start delving into it.
Right, you've heard that, Mr. Smythe.
Yes.
So yes.
Well, I'm happy to be pragmatic.
Yeah.
And,
okay.
And adopt that approach, because about the methodology of the GTAA, because I don't think that will assist the inspector, Ms. Moulton. But on the figures, I think it's Mr. Brown's paragraph 5.47. Could you just give your response, also summarise what you understand the council, what you say the shortfall is, and why you say that Mr. Brown is wrong when he says the shortfall is as bad as he says it is?
I am not sure whether the figure of 28 permanent pitches has been derived from. My reading of the GTAA is that there is it establishes a need for 14 pitches over the period that the assessment covers, 2020 through to 2037. I'm not sure where 28 permanent pitches comes from.
What about 5 years supply? Focus of the inspectors consideration?
Well, certainly there is. It is accepted that the council doesn't have a 5-year supply.
Well, that's all the questions I have for you. If you wait there, maybe after the lunch, or we may make a start now, Leonard Friend will have some questions for you.
I've just got a couple of questions. Can we just go back to footpaths again, to pedestrian footpaths? Are there any public footpaths in the immediate vicinity of the site?
No, not in the immediate vicinity of the site. The position statement plans show the footpath. One of the plans shows the footpath. There's one going through Mare Hills to the north, and one to the south of the site.
Would you be able to access those across the fields, or as a legal access, or you'd have to walk along the road to get onto the footpaths?
As far as I'm aware, you'd have to walk along the road and join the footpaths at the point that they connect with the roads. So yeah, it's considerable distance to the south, the nearest footpath. And yes, as I say, there's one to Mare Hills to the north.
Thank you. Right, just going back to council's provision for gypsy and traveller sites. What provision? It would be helpful, I think, if you could just say a bit about what provision there is. I appreciate there's not a 5-year supply, but what provision there is.
There is a public site at Cemetery Road, which provides 19 pitches, and a private site providing 2 pitches, which is at Linley Road, near Torque in Newcastle.
So the Cemetery Road, is that a council site?
It's run by Aspire Housing, which is the largest registered social landlord in the area.
And the Linley Road one, that's in private ownership with 2 pitches. So presumably that's fully occupied, is it?
To my knowledge, it is fully occupied.
And that's it.
Yes, that's correct. That's it.
Right. But the council are working on a as part of the local plan, they're working on a gypsy and traveller policy allocations.
Yes, that is the case. They are working on a policy. It is something that has been highlighted as being important to progress quite quickly. It was something that was picked up by the steering group in March, which is quite soon after the decision was made to not continue with the joint local plan with Stoke.
So is there a timetable for production of the plan?
I've not seen a timetable, a detailed timetable. I can establish whether there is one from my policy colleagues and can provide one, but I'm fairly sure there's not one on the website, but I might be corrected on that.
Well, perhaps you could ask your colleague. Is there a timetable?
Next regulation 18 stage next autumn, and then the final plan will be in summer 2023.
Okay. Nobody heard any of that on the live streaming. Sorry. Yeah, there's a microphone behind you. Yeah. Could you just identify yourself and
my name's Gemma March. I'm the planning policy manager for the council.
Thank you.
So there is a local development scheme that's been adopted by the council at cabinet. It's on the website. The issues and options consultation Reg 18 is happening now, closes on the 13th of December. We have the second stage is another regulation 18 consultation is next autumn. And then after that, we have the submission plan, which is due for summer 2023. And then it will go to examination. Adoption is envisaged in 2024.
Thank you, that's helpful. Could I have a copy of the local development scheme, please? That's basically the timetable, isn't it?
It is, yeah, with a funny name, but yeah.
Miss Moulton said, Mrs. Moulton said that you were looking at the Gypsy and Traveller aspect of the plan. Is that going to be something that's going to come forward in a more timely fashion than the main local plan, or is it going to all be wrapped into one?
I would have thought it would be wrapped into one because of the need to consult with the public on any options for sites. And it's obviously quite a difficult issue, but we have, as Ms. Moulton raised, it was one of the key issues that came out of the steering group meetings with members early on that needs to be addressed, both the permanent need for pitches and the transient need for some sort of transit provision. There's obviously different options for that. And we've been working with colleagues elsewhere in the council to try and understand what solutions could be possible. But I should imagine that through the call for sites exercise that we're doing right now, we've got it permanently open at the moment, the call for sites. We're trying to, in fact, we've done some proactive work. When we wrote letters to landowners that had submitted sites in the past, we said we were particularly looking for them to confirm whether their site would be available for Gypsy and Traveller provision, or I think it was elderly care. There was one of the needs we were trying to satisfy. So I would expect that we would continue to do this proactive work to try and address the situation, which is not ideal at the moment, which is we're not meeting our need.
Okay, but in essence, if you're talking about adoption of the main plan in 2024, that's more or less the same for any aspect of Gypsy and Traveller.
As I said before, I think it would have to be simply because of the need to consult in the same way and do it formally on the local plan. So yes, 2024.
Okay, thank you. Right. I hope that, well, that was just clarifying really, Mr. Villas. I don't, unless you wanted to ask any question.
It's helpful in the sense that it chimes with what the inspector...
Put your mic on, thank you.
It's helpful in this sense, it chimes with what the inspector in the most recently promulgated decision said, Mr. McGlone.
Oh, right. Yeah,
so
that's the
so it might be
Station Road. Thank you. That's inquiry document
something
2.
I can pick up with Mrs.
Yes,
Mrs.
absolutely.
Moulton, either in a moment
Thank
or later, depending
Thank
on
you.
your...
Right, it's coming up to 12:05.
I'm happy to start.
Okay.
It might be a little bit scattergun, but there's, we could perhaps deal with the matters that have arisen this morning.
Okay.
If you're happy with that, it just seems quite early.
Yeah, I know.
If you want a short break.
So there's a couple of things I want to deal with.
That's true. That's an early.
Okay. You said an hour and a half, didn't you?
Yes.
Okay.
Maybe I could.
No, I'm going to pause now, I think, and we're going to come back at 20 past 1, because I want to now deal with a couple of things with the advocates, and I want to sort the plans out as well. Okay, so if we can come back at 20 past 1, please. Thank you. Right, ladies and gentlemen, hope you had a pleasant lunch. Time for us to begin our work again. Just a couple of things. I've got a copy of a letter from Horton Lodge School. I think that's from you, isn't it, Mr. Villas? So that's it. Yeah, that's inquiry document number 1, I think. Now the Station Road appeal that came from you, Mr. Smythe, didn't it? It did, yes. Can I just check something? In that decision, there's it's paragraph 16, talks about need for Gypsy and Traveller as part of the assessment. Is it 2015 is the most up to date? There's another one after that. Yeah, that's right. That's why I was thinking that can't be right, because that's obviously not the figures that you would tip. That's fine. That clarifies that point. Thank you very much. When was that decision? Okay. Right. I think that's all I have. Anything come up over the lunchtime adjournment? No? Good. Okay. Mr. Villas, can I just check with you? In terms of the order of your witnesses, is Mr. Brown going to be the first witness? He's not, he's last. Okay, yeah. Right, so I'm hopeful that we'll finish Mrs. Moulton's evidence this afternoon, and then we'll see how we're doing timing as to where we go from there. Good. Okay, so we're going to move on now to the cross-examination of Mrs. Moulton by Mr. Villas for the appellants. Yes, Miss Maring.
We're having great difficulty hearing what you're saying.
Oh dear.
We're having difficulty hearing what everyone is saying.
Okay.
So we could ask that we speak closer.
Right. Okay.
The audibility is improved.
Okay. Can you hear me now?
Yeah.
Is that better? Right. Okay. Thank you. I'll move it right close. There we go. And Mrs. Moulton, if you make sure you speak into the microphone, similarly, Mr. Villas as well. You might need to move that mic a bit closer to you, Mr. Villas, actually.
Madam, it's Willers, not Villas.
Oh, sorry.
That's not at all. But I'm called lots of different things, depending on who it is that's calling them. But Willers, yeah,
Sorry.
as in willowers,
Yes. Thank you.
which I think is what it's derived from. So
Could you still move your microphone a bit closer?
even closer, yeah, I'll do those. Good afternoon, Mrs. Moulton. Is that better? Somebody will no doubt notify me if I stray away from the microphone. So can I ask you some questions on behalf of the appellants who sit to the side and behind me? And in doing so, can I perhaps just begin with some periphery points? The first is, if you have it to your available to you, the Station Road appeal. And the inspector just asked you about paragraph 16. And this is an appeal relating to a site in the borough, but situated in the Greenbelt, yes? Yeah.
Yes.
Thank you. And paragraph 16 to 18, we see headed up the need for and provision of traveller sites.
Yes.
And then paragraph 18, there's a reference to the joint local plan with Stoke-on-Trent Council no longer being taken forward. And then the inspector says, instead, the council will pursue its own local plan. This is at a very early stage, with the current timetable envisaging submission for examination at the back end of 2023 with the adoption in 2024. Yes?
Yes.
And I think it chimes with the evidence we heard earlier on from your colleague. Is that right? It's not in the room now. And then the inspector concludes that this programme could well slip. And after its adoption, there would be a period before any new pitches are delivered. Do you have any comment on that?
Well, I've no reason to believe that that there will be any slippage in the timetable. The council is putting forward resources to ensure that the timetable is met where it's within our power. But so we're still anticipating it will be adopted in 2024. And it may be a little while post the adoption before any sites become available for
Yes.
travellers. Yes.
So there'll be an adoption, and hopefully on time 2024, and then a period of time before sites become are constructed and are available for use.
That are on adopted sites, yes.
Yeah, and in this case, although the inspector didn't grant permanent permission for the site in the Greenbelt, he imposed a temporary condition. I think we'll see that in paragraph 2 of the schedule of conditions, page 9. The occupation shall be for a limited period until the end of, well, 31st of December 2025. Is that right?
Yes,
So a period of about 4 years.
that's correct, yes.
I just want to ask you if in this case, were the inspector to accept that, contrary to your arguments, temporary permission should be granted, that a period of about 4 years based upon the promulgation of the local plan and then the subsequent development of sites would be appropriate?
Yes, it would be consistent with this appeal decision.
Thank you. And your concern about the grant of temporary planning permission, just dealing with that, and I think you put this in your proof of evidence at the very back of your proof, 6.31, page 13, is that the risk to protected groundwater supplies that arise from the development require mitigation measures to be carried out, the costs of which would be prohibitive.
Yes, that is what I say in my statement at 6.31.
What I'm wondering is, and Mr. Brown's been asked the same question, but I'm asking you that it's your point. Why do you consider that the costs would be prohibitive?
Well, on being on the site for a temporary period, obviously the appellants have moved onto the site and they've chosen not to undertake these works to date. And yes, it is an assumption that that was on the basis of the costs and in the knowledge that they would only be there potentially there for a temporary period. So it is on that basis. I don't have any additional information as to what those costs might be overall. I can't offer you an estimation of the costs.
So is that an assumption on your part?
It is an assumption, yes.
And just to clarify, the assumption, as I understood it, but correct me if I'm wrong, the assumption being that they hadn't undertaken it at the outset, and so it must be because the cost was prohibitive.
On the basis that, they've carried out certain works and not put in the drainage that was has been identified as being necessary. Yes, it is on that basis, assumption.
Would they have been aware of what was required when they moved onto the site?
Well, they certainly had made within their application an indication that they were going to use package treatment works for they possibly weren't aware of the need to put a permeable surface across the entire site, but certainly the treatment works was something they were aware of at that time.
Yeah, I think we have a groundwater source protection assessment, protection zone assessment, just to put it in its title, dated January 2021, don't we? But that post-dated the planning application.
Yes, that came in with the appeal documents.
Thank you, Madam. You have that. I'm not going to ask you to turn it up, but you'll see the timing of that. Thank you. So in terms of the costs, and Mr. Brown almost I'm not going to say put his finger in the wind, but he gave the inspector a rough estimate of how much he thought it might cost for a packaged sewage treatment plant. I think he said £3,000 to £5,000, £3,000 to £4,000 to £3,000 to £5,000. You don't have any evidence to suggest that is wrong or that is out of kilter with what one would expect.
No, I have no evidence.
All right, thank you very much. Let's move on to other matters then, please. Just generally, again, I don't have a copy of the proposals map, and I'm not suggesting you go and find one, but can you just give me a rough idea of the makeup of the borough? Because we can see that there are two sites that are, one that has now been determined, but another awaiting determination in the green belt. This site isn't, but what's the extent of the green belt in the borough, please?
Yeah, the green belt is around the urban area to the north and to the west. It extends up to the railway line, so it ends in Baldwin's Gate, where the railway line passes through the village.
Right.
And beyond that is open countryside.
Okay. Yes, certainly.
Again, so just so I'm clear, so it comes up to the railway line, so everything that way is green belt, yes?
Yes, up to the urban boundary.
And then everything else within the borough is open countryside.
That's correct, yes.
Okay, thank you. What sort of percentage of green belt have you got?
I don't know. I'm sorry, I can't provide an answer.
Even if you didn't know percentage-wise, if you were looking at an overall plan of the borough, you must have an impression. Is it more green belt than it is open countryside?
No, I would say it's possibly about equal.
Okay.
Equal green belt to open countryside, possibly.
So I'm not familiar with the area, so I may have got this completely wrong, but my understanding is we have Newcastle under Lyme as an urban area, and obviously pockets of other urban areas, Loggerheads being one, to the west of the appeal site. But then around around the urban area of Newcastle under Lyme, the green belt, and then beyond that, in the area where we find the appeal site, the open countryside area. Is that roughly, have I roughly got that right?
Yes. So yes, it goes around Newcastle to the west out towards the appeal site, but it stops at the railway line passing through.
Stops at Baldwin's Gate.
Yeah, at Baldwin's Gate, and then it extends up to the north, up beyond the northern urban area of Kidsgrove.
Right, thank you. So if we're thinking about a hierarchy, or perhaps trying to look for a site, location in Newcastle under Lyme, bearing in mind the cost of developing a site in an urban area, which is going to be greater than a site in the countryside. Would you agree? Just as a matter of principle.
I have no reason to disagree. Yes, in terms of land prices.
Yeah, I mean, in terms of capacity, urban capacity, and other uses for urban land, one's perhaps going to have a lot of competition for a piece of open land within
yes,
an
I think
urban area.
I would agree that land within the urban area might have a premium.
Yeah. And then one's going to perhaps avoid, if one can, greenbelt, unless one's in a borough which is washed over by greenbelt, and this isn't. Is that right?
Sorry, could you just repeat that?
If you were looking for a new gypsy site or land to accommodate a new gypsy site in Newcastle under Lyme, the cost of developing one in the urban area, assuming there was any land available, would be perhaps prohibitive, and there would be competition for that sort of land. We've agreed that, yes?
Yes.
Then looking outside of that urban area, one would try and avoid the greenbelt given its national designation.
Yes.
And then one is left with open countryside, yes?
Yes, that's correct.
And obviously this site is in the open countryside, yes?
Yes.
But there will be areas of the open countryside which, because of, for example, the fact they're in a floodplain, or perhaps situated close to an area of outstanding natural beauty or something of that nature, again, would be perhaps ruled out of the equation.
Yes, there's certain more sensitive areas within the open countryside with more constraints that we would seek to avoid development upon.
Okay. So
I don't know this area particularly well either. So are there areas of outstanding natural beauty in this area?
There's no areas of outstanding natural beauty. We have some triple SIs, but not close to to the appeal site.
Thank you, that's helpful. And then we know that if one looks at planning policy for travel sites, there's nothing in principle wrong with locating a site within open countryside, providing it's not far away from settlements. Yes.
Yes, that's what the policy says.
So, given that where we're likely to find an appropriate place for a gypsy site in the borough of Newcastle under Lyme, it's also right to say, isn't it, that it's unlikely that such a site is going to have particularly good access to public transport.
Well, it certainly won't have the same access as within the urban area. So there are sites where you can get safely to bus stops. There are footpaths, but yes, it's the bus service in the rural area is not as good as in urban areas.
Understood. All right. So with that context in mind, let's perhaps turn to the other documents that we have apart from your statements, your proof of evidence, and I'm particularly going to ask you just briefly to look up the statement of common ground and the position statement. First, the position statement, and again, we'll come back to the location of the site in relation to public transport in a moment, but I just want to tie up a few other loose ends first. So the position statement.
Apologies, I don't appear to have either the position statement or the statement of common ground.
Okay. We may be able to find. I might be able to get to the point another way. Madam, if I could ask you to keep open or note paragraph 1.2 of the position statement, and then perhaps ask Mrs. Moulton to turn up in her proof a paragraph which reflects that. It's a paragraph dealing with need. And paragraph 5.9, please, Mrs. Moulton.
Yes, I've got that paragraph.
You've got that. Thank you. And I think this is almost an exact reflection of what you find in the position statement, madam. But 5.9, you talk about the 2020 Gypsy and Traveller Accommodation Assessment. And you say it identifies an increased need for pitches than was identified in the 2015 version. You say it indicates that for the 5-year period between 2021 to 2023, 2024, there is an overall shortfall of 5 pitches for gypsies and travellers, and an overall need for 7 pitches over the entire assessment period, 2021 to 2036/37. Now, as I read that, there seems to be an overlap between the two figures and the two periods. Am I right in thinking that, in fact, that should read that over the entire assessment period, there is a need for 12 pitches, 5 plus 7? Or is the 5 encapsulated by the 7?
I think the 5 is encapsulated in the 7, but if I can go to the assessment.
You see, where the position statement perhaps would be helpful to you, because
yes,
in the following paragraph in the position statement, having given those figures and those periods, you've agreed with Mr. Brown that there's a need for at least 12 pitches for the gypsies and travellers in the assessment period.
Okay.
So that equates to 5 plus 7, I think.
So I'm looking at table 6.4 of the assessment.
Which page is that, please?
Which is on page 45. which it's core document 9.
Yep.
So at the end of the table, on the final line. Yeah, sorry. Page 45. So that talks about it provides a summary of the need over the entire assessment period from 2020 through to 2037, and it indicates after turnover and potential pitch development are considered, there is a need for seven pitches.
Sorry, so where did your 12 come from then? Do you want to have a look at the?
Yes, I'm not entirely sure now, but yeah, that may have been an error. Yeah. Yes, it's possibly in a correction or an amendment that Mr. Brown made that was accepted, but I can't now recall.
Yes, it says it's a position of council and the appellant that there is a need for at least 12 pitches for gypsy and travellers in the assessment period. In the appellant's opinion, the actual figure should be much higher, but you've accepted the 12.
Yes, but that appears to be in error. And looking at the final line of the table 6.4, which talks about, which identifies the need in Newcastle under Lyme.
Okay, well, we've heard Mrs. Moulton's response to those questions. So I'll ask Mr. Brown briefly about it, but again, I'm going to do my best to avoid the temptation to dive deep into the.
Can I just be clear?
Yeah,
so in the position, it's a pity you haven't got your copy of your own position statement, but anyway, so in the position statement, you say that the GTAA 2020 estimates there's a need for provision 5 pitches for gypsy and travellers in Newcastle during the period 2021 to 24-25, and a further 7 in the period 2021 to 36-37. So you're saying that's wrong?
Yes, I would want to clarify, correct that, yes, and say it's 7 overall.
So it's 7 overall. So it's 7 from 2021 to 36-37.
Yes, according to table 6.4.
Okay.
Thank you. And while we're on the same page of your proof of evidence dealing with need, you in 5.11 you refer to those 2 Greenbelt cases, one of which we've now got the decision for. And then 5.12, you say, a hearing was held last month in respect to the Station Road appeal, and a date in February has been scheduled for the hearing on 5 Bogs Cottage. Each site would provide a pitch and would contribute towards the identified need if allowed. Now, putting aside Bogs Cottage, which we haven't yet got the decision on, what we have got is a temporary permission on the Station Road appeal. So will you agree with me that doesn't actually contribute to the need identified, given that it's a temporary permission?
It would contribute during the temporary period that it's in place. So, yes.
Yeah, well, the thing is that to contribute to the permanent need or the need for permanent provision, it would need to be a permanent grant of planning permission, wouldn't it?
I accept that, yes.
Yeah.
Can I just clarify? So that the Station Road appeal is for how many pitches?
1.
Just 1. Okay. And the Bogs Cottage, how many is that for?
1.
That's only for 1 as well. Okay.
Thank you.
Thank you.
Thank you, madam. And while we're on the subject of need, the council-run site at Cemetery Road, I think it is. When was that established, please? Do you know? It may be something I can discover and interrogate in the GTAA, but
I don't know for certain. It's been there some time,
yeah.
In excess of 10 years. And possibly quite
Okay.
a considerable period longer than that. I can't say for certain.
And the last site, private gypsy site that was granted planning permission by this council was which site and when, please?
It was the Linley Road site, and I don't know for certain. I think it's somewhere around 2008 is what I recall, but yes, I'd have to check.
Yeah, thank you. And
That was the private site, wasn't it? Is that right?
Yes,
Yes,
that's right.
that's not actually available.
no,
Should a
no,
picture come up? Is that right? Yep.
I think that's right, madam. There were two pitches on, basically two pitches on that site, I think. And it's
Yes, that's my
private site,
understanding.
Yeah. And in terms of the Newcastle Underlying Council site, I know it's run by another organisation, but what's the waiting list for pitch availability on that site, please?
I haven't got that information. I did note there was reference to it in Mr. Brown's statement,
Yeah.
and it was a considerable period of time that I can't bring to mind. I have sought information from Aspire to understand what the position is on the pitch that we were aware was vacant, and I've not received any clarification as yet. We can seek that information from them if that would assist the appeal.
Yeah, I suppose the next question would be, do you dispute the number? I think it was actually a number given to one of the appellants who visited that site of a waiting list, I think of the order of 17 families waiting for a pitch on that site.
I've no basis to dispute that. I've no information to the contrary.
Yeah, thank you. It's helpful. And then we were agreed, and I think let's just run through the positions. I know you haven't got it, but I'll just confirm there's nothing else that is disputed. Actually, it's the statement of common ground, which I don't think you've got, so I'm going to read it to you if you don't mind. Paragraph 5.7, madam. Other material considerations, just to tidy these points off. Agreed, there's an unmet need for gypsy and traveller sites in the borough. Just a dispute between the council and Mr. Brown as to the extent. Yes.
Yes.
You can keep your microphone on all the time if you want. So you're going to turn it on and off, but we can have it on at the same time. The council doesn't suggest there are any alternative sites available to residents of the appeal site.
Yes.
Right? Thank you. And acknowledges that it cannot identify a 5-year supply of deliverable land for the provision of new gypsy sites.
Yes.
Yeah. And that these are all matters which weigh in favour of the appeal proposals.
Yes.
Yeah. Thanks. And those were matters which you, as the author of the officer's report, had in mind when you made the recommendation for refusal. Is that right? Yes. Yeah. And there's no real difference on those matters, is there? In terms of the 2019 application when compared with the 2020 application, nothing really changed between those two applications on that score.
In respect to that matter, no.
Yeah. Okay. Thank you very much. Just help me with this. In terms of the 2018, 2019 planning application and its refusal, were you the author of the report in that case? Or?
Yes, I believe I was, yes.
Yeah, I wasn't sure, but I thought you might be. Thank you. Excuse me, madam. So back to your proof of evidence, please. And in section 5, you deal with planning policy. I just want to see if we can agree on some matters of policy. You refer to the work on the joint local plan. We know where that's gone. And in terms of the actual policies that are relevant for the purposes of this case, clearly we're going to be talking about policy, core strategy policy 7. But in section 5, and particularly page 6, you refer to the neighbourhood plan.
Yes.
5, 16, 17 and 18. And in 17, 517, you say, whilst neighbourhood planning may not initially seem pertinent to this appeal, the Borough Council is strongly of the view that a robust baseline of neighbourhood plans is a key element to ensuring that national planning policy is integrated effectively with local needs and expectations. Yep.
Yes.
And what I wanted to ask you is this, without, and I haven't had a look at the whole of the plan, neighbourhood plan, is there anything about gypsy site provision in the neighbourhood plan?
There's no provision within the neighbourhood plan. I think consideration has been given to whether there was a need to address that within the plan.
Right.
A need wasn't identified, so there is no policy relating to such matters within that document.
So am I right in thinking that one wouldn't be expecting the neighbourhood plan to deliver sites which might address the identified need?
Well, the neighbourhood plan doesn't seek to deliver sites to address that need, the identified need, no.
So we're really looking forward to the local plan, which is hopefully to be adopted in 2024 for that job.
Yes, the local plan will undertake that role.
Yeah.
Well, Liz, can I just ask that the neighbourhood plan, would the, so obviously you've got an overall need that's been identified across the borough. Does it actually come down to more fine-grained need in particular parishes or neighbourhoods that would be related to a neighbourhood plan?
We haven't identified a fine-grained need through the assessment. It is possible that yes, there will be allocations within the local plan.
Yes,
and that will consider whether there is any more local, specifically identified needs that ought to be addressed and the site found to meet that need.
Right, because I believe you said in talking about the neighbourhood plan, you said no need was identified.
Through that process, yeah. It was considered as part of their assessment of what the plan should cover, and they didn't identify a particular need that needed to be addressed through the.
So how did they assess it then in their particular neighbourhood? If you've got the GTAA, my understanding is a much wider document, and so it would identify the need across the whole borough. So how can the neighbourhood plan, if you said that there's no need identified, how did they identify there was no need in their neighbourhood?
Well, my understanding is that they undertook a survey and sought to establish whether there was any need that had been expressed by people.
Sorry, a survey of who?
Gypsies and Travellers, I believe, but I'd have to check on that. It's part of their evidence base that I can't say I know in great detail.
So there are other Gypsy and Traveller sites in that neighbourhood?
No, there aren't. No, I think it was more, I assume it was of a similar nature to the accommodation assessment that was done across the borough as a whole. But they applied a similar assessment.
They duplicated what was carried out in the GTAA,
potentially,
and they've surveyed all the gypsies in the borough to find out if anybody needed a plot in that neighbourhood area. Is that what you're saying?
I can't say that is what has happened, because I'd have to check the evidence base to fully understand it. I do know that there is reference to within the document that they have considered that and have not identified a need that should be addressed within the policy. I can look to the evidence base and understand, get a greater understanding of what they've done to assess it, and come back to you at a later point. I can't add any further at this point, I'm afraid.
Right. Okay. So basically, your statement that no need was identified, you can't really point me at the evidence for that.
Not while I'm sat here, no, but I can go back and look interrogate the neighbourhood plan and pass that on.
Okay, I'll leave that with Mr. Willers.
Thank you, Madam. What I'm generally concerned about is any assumptions, and so if you can interrogate the neighbourhood plan or the process to see whether or not there was in fact any assessment of need, which goes beyond the gypsy and traveller accommodation assessments, which clearly they had the 2015, if not the 2020. That would be helpful. Otherwise, I think we ought to not base our understanding on any assessment, any assumption. So I was going to ask you, please, about policies N20, local plan policy N20, which is a saved policy and quite dated now, and the neighbourhood development plan policy DC2. And Mr. Brown suggests that policy DC2 supersedes policy N20. That's the way he puts it in his proof of evidence. And I just wonder if you agree that what we should be looking at is policy DC2, not policy N20.
I think they're both policies that are relevant to the consideration of the appeal proposal.
Right, thank you. Just looking at the language deployed in policy DC2, talks about supporting development which enhances the character and appearance of the area, to put it in to paraphrase it. Yeah.
Yes.
What it doesn't say is if you have a development which doesn't enhance the character and appearance, you should refuse planning permission, does it? It's not a negative, it's a positive policy, a supportive policy.
That's correct, but the aim is to ensure that development doesn't erode the landscape quality. So therefore, if there is harm, then it wouldn't be in accordance with policy DC2 of the neighbourhood plan.
Have you got a copy of that? Thank you.
Sorry, it might just be me, but it's getting quite cold in here. People feeling a bit chilly? Yeah. Is it possible to get the air conditioning turned down a little bit? I appreciate we need ventilation and whatnot. It's getting a little bit chilly though. Thank you.
Thank you. Rather than search the internet for policy DC2 and N20, which for some reason I've never been supplied with, I'm going to leave Mr. Brown's interpretation to him of the policies, and he can explain what he thinks about the hierarchy. But the policy that we do have in the development plan that clearly relates to gypsy site provision is policy CSP7, yes?
Yes.
And that policy, if you have that in front of you, if you can turn it up, please, identifies 4 criteria
Yes.
And begins with these words: additional pitches will be located wherever possible on sites which 1, 2, 3, and 4. Yes.
Yes,
And you see the words wherever possible.
I do.
It doesn't mandate or require each and every one of the 4 criteria to be fulfilled, does it?
I disagree. I think the intention is that when considering applications for sites to provide pitches for gypsy and travellers, we seek to ensure that the 4 criteria are satisfied. And I think that point is to some extent supported by the associated text at paragraph 6.56, which says that sites will be identified in future development plan documents as set out in each authority's local development scheme that satisfy the criteria. There's no qualification or clarification that it's some or not all of those criteria that need to be met. So we interpret it on the basis that all criteria should be met, but there may be nevertheless be reasons why planning permission should be granted if not all criteria are met in certain cases.
Okay, let's just perhaps break that down. First of all, would you agree with me that paragraph 6.56 in the commentary, in fact, is a reference to strategic planning? Well, I say strategic at the borough level. It's a reference to the council itself identifying, no doubt taking a sequential approach, sites which ought to be allocated for gypsy site provision. It said sites will be identified in future development plan documents as set out in each authority's local development scheme that satisfy the criteria. So it's an approach which this council intends to adopt in identifying sites in the future which might be open for a development.
Yes, I accept that, but I don't see any basis upon which there is reason to conclude that the criteria don't all have to be met. There are standard criteria that are applied in most authorities, and I think it's reasonable to expect that each criteria should be met, and where they are, the proposal should be supported.
Sorry, gentlemen. It's a bit distracting. We can hear your conversation.
Just on the meeting.
Okay. 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 All right. Well, thanks very much for having a look anyway. Thank you.
Yes, I was saying that I don't see any basis upon which to conclude that the intention of the policy was not to ensure that proposals for gypsy and traveller sites should only meet some, not all of those criteria. My interpretation is that they should meet all the criteria, and their standard criteria that I think is typical of policies across the country.
Yeah, thank you. Now, if the policy had been worded, additional pitches will be located on sites which 1, 2, 3, 4, then that might be right. But the reality is that the policy includes the words wherever possible, doesn't it? So you can't be right, can you, about the approach that ought to be taken?
I think it's a reasonable interpretation of the policy to consider that all 4 criteria should be met. I note what you're saying, the reference to whichever possible, but I think the starting point is that all 4 criteria should be met, and that is the approach that we take.
The approach you take, thank you. But what do those words "wherever possible" mean then, in your view?
That there may be, as with all policies, there may be circumstances where development isn't fully accordant with the policy, but there may be other material considerations that justify the granting of planning permission.
You see, this policy, unlike others, doesn't refer to the possibility of planning permission being granted as a consequence of other material considerations out with the criteria, outweighing any conflict with the policy, does it?
It doesn't specify that, no, but that is the approach taken to policy.
I mean, the words "wherever possible" are related to the 4 criteria, and that's it. Any person reading this policy would assume that wherever possible, those four criteria should be met. But if not, that doesn't mean to say planning permission will be refused.
I don't think there's anything further I can add. The interpretation of the policy is that the starting point is that all 4 criteria should be met.
All right, thank you. Again, perhaps just looking at those criteria then. The first one, provide good access to shops, education, healthcare facilities and other essential services. There's no dispute between us about that. That you have agreed is satisfied, yes?
In terms of the proximity to the facilities in Baldwin Gates and Loggerheads and the accessibility by vehicle, yes.
Yeah, thank you. And Baldwin's Gate, I don't know it, but I understand there's also a train station there. Is that right?
No, that's not correct.
Is that not right?
No.
Where's the nearest train station?
Crewe and Stoke. I haven't measured the distances to know which is nearer.
I know that there's none at Newcastle under Lyme, otherwise
No.
I would have come straight here.
No, there's not. Yeah,
So there's a railway line at Baldwin's Gate, but it doesn't stop there.
that's correct.
Thank you. And then second point, please, point 2, provide safe and convenient access to public transport and the highway network. Just looking at the language used, safe and convenient access to public transport and the highway network, no issue with us now, between us now, as to safe and convenient access to the highway network.
That's correct, yes.
Providing, of course, that the inspector is satisfied, as the council is, with the agreement reached on that point. It says provide safe and convenient access to public transport. And again, let's assume for a moment that you're right and one has to conform with this criterion. What it doesn't say is how that safe and convenient access to public transport should be provided, does it?
No, it doesn't specify that, but the intent is that it's on foot. If you got in a vehicle to drive to public transport facilities, you would no doubt, in most cases, just travel on to the final destination. I think it does mean you should be able to safely walk to public transport, or that is implicit in that criteria.
Right, just break that down for me, please. Is there anything in the commentary attached which says that safe and convenient access ought to be by foot?
No, but I think that is a reasonable and pragmatic interpretation of that criteria of the policy.
Is there anything in planning policy for travellers' sites, which I know post-date CSP7, that suggests that there needs to be a safe and convenient access to public transport by foot?
No, I don't believe that there is, but again, if you are seeking to provide access to public transport, then there should be the opportunity to be able to get safely there on foot.
Okay, let's just, I mean, we can run through many examples, I'm sure, park and ride being one, but another, dropping a relative off at a bus stop or a train station on the way to and from work. I mean, you agree with me that one doesn't necessarily have to get to public transport by foot in order to access it?
No, but the majority of people in the majority of journeys do access on foot bus stops. They don't drive there in any way, shape or form or get dropped off. It does happen, I accept that, but not in the majority of cases.
But in rural areas where, you know, buses are few and far between and bus stops equally sometimes somewhat distant from people's houses. It doesn't work like that, does it?
I think the people who access the bus stops, they access the ones that are near to them and that they can safely get to on foot. They want to be want to be reliant upon other people to get them to the bus stop, or if they do get in a vehicle to drive to the bus stop, which I think is not typical, then the chances are, as they're in the vehicle, they would carry on to their final destination.
Well, I mean, the idea of somebody driving to a bus stop and then leaving their car and getting on a bus is perhaps only likely in a park and ride type situation.
Yeah, in an urban area, yes.
Yeah, but the idea of driving perhaps to work, but on the way dropping somebody off at a bus stop is something that we all have experienced, I'm sure, either as the driver or the passenger, particularly as parents.
On occasion, but you, as a parent, I would wish my children to be able to independently access public transport safely. To have that independence, they should be able to get there safely. And if they aren't able to do that, I think that is a difficulty for the children and for the site. That it's a deficiency.
Can I just ask a question? So there are residential properties in the immediate vicinity of the appeal site.
There are. They're on the A51, and there is a footpath along the A51.
Right. Okay. So this part of the A53, isn't it, that comes up? There's no houses. I was thinking about like school buses. Well, where do they stop to pick up children?
Well, I assume that they stop on the A51. Then there aren't houses till you get to Ashley and Loggerheads along the A53. It's some distance away, and yeah, so they would pick up school buses. I would anticipate within the village of Ashley Heath and Loggerheads.
So the bus stop on the A51.
Yes.
That's not really used by school buses, essentially.
I don't know that it is. The village of Blackbrook, there is a lay-by, so vehicles can pull in there. So they would necessarily pick up from a physical bus stop. There are places where you can pull off the highway safely to pick up children. But I don't. Yes, I'm making assumptions, and I don't know the answer to that particular question. But the access from the properties, the occupants of the properties in Blackbrook to the bus stops can be done via pavements along the A51.
Okay, all right, thank you.
We can see the bus stops, can't we? One of the plans, which is plan 2, I think, which is provided. They're located at the top of the A53 as it joins the A51.
Yes.
On both sides of the road. Before one gets to the farm shop and the public house, the one with 2 next. Just on the location of the farm shop, maybe it doesn't help my client, but I'm told that maybe not quite where it's located on that plan.
Yes, that was pointed out. Yes, the farm shop is further along the A51 away from the site. There is a corrected plan now on the appeal document library, and a copy has been provided to the inspectors. Yeah. Yes, yes. Sorry for that oversight. Yes.
I assumed you had.
But now I know. Maybe it was around. Yeah, so we know in fact, and everybody else apart from me knows that this is further on the road. Thank you. And the real concern you have is about, particularly let's talk about children. Children, if they were allowed to, leaving the appeal site gate and walking up on the verge to the A51, the junction where they could then join the pavements. But
yes.
Prior to that, they're on the verge.
Oh, on the carriageway, the verge is often overgrown.
Thank you. And actually the position. far as other public transport is concerned.
So could you switch your mic on, please?
Yeah, certainly. Thank you very much for reminding me. As far as other public transport is concerned, your reverence doesn't relate to taxis, does it? Obviously, taxis can drive in and out. There's no concern about that.
No, there's no, yeah.
Yeah. So there is a ready form of public transport that pretty much everybody in this country can access wherever they are, and that includes these appellants.
Yes, yes.
Thank you. And then the other point I think you raised about school buses, and I'm only going to ask you about just to confirm whether you agree on in respect of one individual, the young man with the medical condition that requires him to attend a special school. He gets driven to and from school by a vehicle or a bus that enters the site on a daily basis. That's right, isn't it?
I've no reason
Yeah,
to dispute that.
know.
Yeah.
Okay, thank you. Thank you. So we've looked at policy CS P7 in relation to criterion 2, and we understand the council's concern about safe and convenient access. So I'm going to move on from there, I think, if I may, because I think we can see where the battle lines are drawn, as it were. Can we talk then instead about the criterion 3, which I think everybody agrees is either met or is capable of being met? The infrastructure criteria.
Could you just for the inquiry, just
Shall I read it
explain?
out?
Yes, please.
Yeah. So there are 4 criterion, and the third criterion is that additional pitches will be located wherever possible on sites which have the capacity to incorporate all necessary on-site infrastructure, for example, parking, storage, waste disposal, play and residential amenity space. Yes.
Yes.
Thank you. And then 4, the fourth criterion, and this is one in issue, that they minimize any negative impacts upon local landscapes, environments, and neighboring communities.
Yes, that's fourth criteria.
Thank you. And you see the word minimize. Am I right in thinking, Mr. Brown, right in thinking that must be interpreted in a reasonable way, yes, and in a way that doesn't frustrate gypsy site developments?
Yes, I would agree.
Yeah, thank you. And Mr. Brown suggests that in fact what it means is that one shouldn't refuse planning permission unless the harm arising from the proposed development is unacceptable.
Yes.
Thank you. So that's I'm grateful. So that's really the test. And ultimately, the inspector will visit the site and have reach her own conclusions. But clearly, we have 2 experts who say different things. And so I'm going to ask you about your opinion, if I may.
Okay.
So looking at your proof of evidence, please. And particularly paragraph 6.7 onwards, and noting that you were the officer who wrote the 2020 report. Perhaps if we can turn that up, madam. I've got it as a separate document, but it may be that it's in one of Mrs. Moulton's exhibits. Certainly.
So that's the report
20/00368/4.
called document 4.
Oh, thank you. Yeah. And we can see in the first page recommendations that you set out for the local authority, and which were ultimately to find their way into the reasons for refusal.
I'm sorry,
I'm sorry, it's not. No, that's the decision notice.
yes,
Oh, I'm sorry, I'm looking at the committee report.
right, yes.
Oh,
I've got there now, yes.
thank you.
It's core document 2.
So document 4 is the decision notice, and doc 2, the committee report. Thank you. So this is your report, Mrs. Moulton, and the recommendations 1, 2, and 3 are reflected in, I think, word for word, in the reasons for refusal.
Yes.
Thank you. And just looking at refusal reason number 1 in the recommendations in the report, it reads: the proposed development is in an unsuitable location within the open countryside, away from services and facilities, and without safe and convenient access to public transport. So we've addressed that, and results in harm to the intrinsic character and beauty of the countryside due to the enclosure of the site, affecting the character and openness of the landscape. Yep.
Yes.
And it's the word "due to the enclosure of the site"
Yes.
seem to be the premise for the conclusion that you reached in that regard. Is that right?
Yes.
Thank you. And we can see that, can't we, in the body of the report, paragraph 1.8 and 1.9, where you address changes in the scheme from the scheme that was refused the year before.
Yes.
Yeah, thank you. And in essence, the concern was the difference between a scheme which had a proposed open post and rail fence for the boundary detail compared with a scheme which incorporated an acoustic fence around the site.
Yes.
And you've explained that your impression was that the acoustic fence was to wrap around the site. But on interrogating or looking at the plan, it's become clearer that in fact it is in fact an acoustic fence which will only run along part of the eastern boundary.
Yes.
Right, thank you. But there is actually on site at this point in time a continuous fence around much of the site, and you know, if it were to be, if that were to be the proposal, then no doubt your concerns about the enclosure of the site and its impact on openness and the surrounding countryside would stand. Is that right?
Well, yes, the retention of that fence would mean that, yeah, the concerns stand, but the concerns, even with the post and rail fence on the southern and northern boundaries, there are still concerns about the visual impact of the development on the countryside.
Why is that? Because in 2019 you didn't have those concerns.
Well, on the basis of the layout of the plan as the site has proposed, the position of the amenity buildings, and the stables, there is sort of continuous buildings with gaps, but continuous buildings along that southern boundary, taking up quite a proportion of that southern boundary. So there is still an element of enclosure that is considered to be harmful to the character and appearance of the countryside.
Right. Where do we find any reference to those concerns in the officer's report?
The report doesn't say that.
Where do we find those concerns reflected in the reasons for refusal?
The reason for refusal doesn't specify those points.
No, because it's based upon your view in 1.8 and 1.9 that the change resulting from the enclosure by the acoustic fence is the change which leads to an objection.
It does, but the concerns remain in the knowledge, even with the knowledge that the acoustic fence is only on the eastern boundary.
But I'm just trying to explore where we find that in the officer's report, which you wrote.
And I've accepted that it isn't in the officer's report.
Where do we find it then in your much more recent proof of evidence?
And it isn't in that
So this
either.
is something that you're telling us for the first time in evidence today without there being any written proof to that effect?
Yes, I accept that. That is the case.
Thank you. Madam, I won't delve into that any further. I'm going to make submissions on the weight to be attached to that opinion later. Do we have a copy of the site layout plan, or could you provide us with a copy of the site layout plan that was before you and the council for the 2019 application?
Yeah, that'll be on record, and we can provide that.
That would be helpful, yeah, just as well. Maybe that we can all see it without you necessarily having to dig it up. If we go to the, I assume everybody's got a copy of the reports, which we're now no longer really concerned with, but sorry, forgive me, madam, I'm just going to dig it up. Might be the noise assessment report. Yes, there's a noise assessment report, which included some site layouts, which I must admit I hadn't appreciated the provenance of. But the noise assessment report, page, I think it's beyond the written text, madam. There are figures, or what are described as figures, and turning into the first figure 1, we have proposed layout, development layout, and you see, if you've got it, Mrs. Moulton, the proposed layout as it was back in 2019. I'm just trying to help the inspector understand your position.
So can I just be clear that that figure 1, that's the layout as per the 2019 planning application.
Yes.
Is that right?
Yes.
Okay.
We have a plan which we can have photocopied.
Okay.
If anything, all it does, it just helps you, madam, understand the evidence that's been given.
Do you accept that, Mrs. Moulton? Are you happy with that?
I would need to check from the planning file whether that is the correct plan, but I've no reason to think it isn't.
Okay. Thank you. And I mean, to be fair, the buildings are located along the northern boundary on that plan.
Yes, they are.
So and it doesn't appear as if there's any landscaping to the south of the development.
Not on the plan. There's no landscaping shown.
All right. Well, let's move on, please. So, looking at your proof of evidence, then, and noting that you've made points today which aren't in it. Paragraph 6.8, just to confirm. There it talks about a 2 metre high acoustic fence having been erected. In fact, that's what's proposed. There is a fence there, but it's not necessarily to the design and specification required for it to be an acoustic fence.
Yes, I can't confirm it is to that correct specification.
And I think the appellants will tell us that it isn't yet in conformity with that. 2.9, you say the prominence is exacerbated further due to the current layout, as 2 mobile homes are sited with their longest side parallel to the fence on the southern boundary. And so that's a reference to the current layout. And we know that the proposed layout is
Is
as set out
different.
in
Yes,
the plan. Yeah.
yes, I accept that.
Just while we're on the subject of mobile homes, I think you clarified my learned friend's opening actually in this respect by informing the inspector that at the time that the injunction, which was first sought, which put a stay on development, effectively a status quo injunction, there were already 2 mobile homes and other caravans on the site. Is that right?
Yes.
Yeah. So then the injunction said put a stop to the development of the site on pain of committal for contempt. And then what happened was that the appellants, either themselves or through their representatives, asked the council if they could have permission to swap caravans for mobile homes. In other words, to bring the number of mobile homes up to 4.
That's correct. Yes.
That's right. And that agreement was forthcoming. The council agreed, but made it clear that it was at the appellant's own risk.
Yes.
Because they might have to remove them.
Yes.
Yeah. Okay. And then just to tidy up this point, you referred to the stable not having been on the site at the time when the injunction was granted. Yes.
That's my understanding. Yes.
Yeah. But is it also your understanding that a request was made to put the stable on the land? I think it's on the land edged in blue, and that the appellants were told they could do that provided it was movable. In other words, on metal skids.
I'm not aware of that. No.
Do we know? Well, I'm not suggesting it was you who made that.
Yeah,
who agreed to that.
I've not heard that before.
Do you have an enforcement officer with this is one of those wide questions, with the forename Paul?
Yes.
Yeah. Okay. Well, I think it will be said that an enforcement officer with the first name Paul agreed to it, provided it was movable. It might be something that you can investigate and agree, but perhaps it doesn't matter. But what we have is a stable on the site which is movable. Is that right? Do you agree with that?
Well, it has been moved.
And it has
yes, so that is it is moved. It's a sizable building.
Yeah.
It wouldn't be easily moved, but it has been moved.
Yeah.
So I have to acknowledge it can be.
Yeah. Okay. Thank you. Sorry, madam. Were you going?
I was just going to ask, albeit you might not have given that advice, if you were asked that question and it was movable, what would your answer be?
Well, it's the degree of permanence. Give small buildings that are easily moved. Aren't necessarily development and don't require any formal consent. Given the size of this building, I wouldn't have given that advice. I think it's of a size and a permanence. Whilst it is physically possible to move it, it's not so easy to do so that we would conclude that it's not development requiring permission. So my advice would have been different. But I don't know whether the officer was aware of the size of the building or asked that question.
Told that, in fact, just to clarify, the gentleman, Paul Lageman or
Layman, yes.
Layman, and he's the gentleman who just walked out of the room. Right?
He was there. I don't know when he
Just
walked out of the room.
okay.
Yes.
All right. Okay. Thank you. And then looking at going through the section of your proof, 611, you refer to the regular form of fencing combined with the positioning of the caravans within the site has the effect of creating a corralled environment. And this is, again, your reference to the current position, the current state of the site.
It is, but I would consider that to apply to the proposed as well.
Yeah. And notwithstanding a post and rail fence, I mean, I suppose post and rail fence is what you'd expect in a corral.
Yeah, it is open in nature. It's not solid like the fence that is there, but the combination of the fence and the buildings, the position of the buildings on that boundary, I think the same conclusions would be reached by myself.
So it's the position of the buildings as is,
No,
Or
as
as
proposed,
proposed?
the amenity buildings, which are there's two of them along the southern boundary, and the stable, which forms in combination with the post and rail fence, a reasonably solid southern boundary with gaps. But yeah, there's an element of solidity to that boundary because of the position of the building.
And have you taken into account the landscaping proposed?
Yes, the landscaping would obviously, well, in my opinion, soften the appearance of it, of the site, but wouldn't mitigate the adverse visual impact. It would still be apparent within the landscape, obvious and quite, noticeable, prominent.
So the issue is around the amenity buildings and the stables. So if they were relocated elsewhere, that would overcome the issue?
Again, that would help to soften the appearance of the site. If the buildings were moved away from that southern boundary, it would assist in the visual impact of the site when viewed from the A53.
Thank you, Madam. And just looking at, have you got a copy of PPTS, Planning Policy for Traveller Sites?
Yes.
Thank you. So just to round off this point, paragraph 28, page 8, Madam, says local planning authority, sorry, forgive me.
Sorry, what was the paragraph?
Paragraph 28. Says
yes,
local planning authorities should consider how they could overcome planning objections to particular proposals using planning conditions or planning obligations, including, and then there are 3 different suggestions. But in this case, perhaps a 4th might be the imposition of a site layout scheme which identifies appropriate positions for the amenity buildings to be located. So that they can be agreed with the council.
Yes, that. I mean, yes, a condition could address the position of the buildings and other features within the site.
In fact, I don't know, I haven't looked back at it, but whether or not you can remember whether the list of conditions agreed with Mr. Brown include a site layout condition.
There's certainly not one that suggests an amendment to the site layout. Okay. There is one, I think, that seeks implementation of the submitted layout.
Thank you. Just while we've got PPTS open, Planning Policy for Traveller Sites, for anybody who doesn't know it intimately, if you turn to page 6, please, and decision taking is the heading, Policy H, determining planning applications for traveller sites. We can see, can't we, the well-known requirement that applications for planning permission must be determined in accordance with the development plan. That's paragraph 22, unless material considerations indicate otherwise. And then 23, applications should be assessed and determined in accordance with the presumption in favour of sustainable development and the application of specific policies in the NPPF, National Planning Policy for Framework.
Yes.
And this planning policy for travel sites. So I wanted to ask you, please, about the presumption in favour of sustainable development. And that harks back to the National Planning Policy Framework, paragraph 11. And just seeing whether or not we can agree with the approach that the inspector ought to take when determining this appeal. I appreciate that your case is there's a conflict between the proposed development and 2 elements of policy CSP7, yes?
Yes.
Yeah, but assuming that the inspector concludes that any conflict is, there is no conflict, or it's so minimal as to be capable of being ignored, then would you agree with me that in this case, looking at paragraph 11D of the NPPF, that because we're dealing with a development for which the key development plan policy CSP7 is out of date, the inspector ought to apply the presumption in favour of sustainable development and grant permission unless any adverse impacts of doing so would significantly and demonstrably outweigh the benefits.
Well, I have no reason to think that policy CSP7 is out of date, but if that was the conclusion, then
Right. Okay. Well, let's just have a think about that. Policy CSP7 dates back to 2009. Is that right?
Yes.
Yeah. So since then, we've had the National Planning Policy Framework issued in 2012. Yes.
Yes.
And more importantly, you might think planning policy for travellers sites first issued in 2012 and more recently updated in 2015.
Yes.
And the policy CSP7 is not based, is it, on an up-to-date assessment of need? In fact, it predates the 2015 GTAA and the 2020 GTAA by at least 6/11 years.
It does, but I don't see why the criteria set within CSP7 it becomes out of date on the basis that when the policy was written, it was the evidence base to the local to the core spatial strategy was an older accommodation assessment. It was based on an older accommodation assessment. So, and I don't see that there's any conflict with national policy. So on that basis, I don't consider CSP7 to be out of date.
Right. Planning policy for traveller sites doesn't just require decision makers to take account of various factors when determining whether or not to grant planning permission. And we're in that section in the PPTS right now. But it also requires local authorities to assess need, doesn't it?
It does, yes.
Yeah, and we can see that in paragraph 10, page 3. Local planning authorities should, in producing their local plan, identify and update annually a supply of specific deliverable sites sufficient to provide 5 years worth of sites against their locally set targets. Do you
Yes.
see that? Yeah. And we know, don't we, in this case, that the council agree that it hasn't done that job and it doesn't have a 5-year supply of deliverable sites.
Yes,
Yep.
That's agreed.
Thank you. That I'd suggest is another reason for the inspector, if there was needed, another reason to conclude that policy CSP7 is out of date. What do you think about that as a suggestion?
Well, the policy CSP7 sets criteria for the assessment of proposals for gypsy sites. I don't see why the council's lack of a 5-year housing land supply makes those criteria any less relevant for consideration in the determination of the appeal.
Okay. Have a look. Have you got the National Planning Policy Framework, or at least this,
yes,
this particular provision? Grateful. So there's a box. I don't know if you've got it, madam. And Mr. Brown will tell me if I'm barking up the wrong tree in a moment, but I'm going to ask you just to look at paragraph 11.
Yes.
And then you'll see for plan making, this means that. Mm-hmm. And then for decision taking, this means that. So it reads, just so that those in the public gallery can understand, plans and decisions should apply a presumption in favour of sustainable development. For decision making, this means, and then D, where there are no relevant development plan policies or the policies which are most important for determining the application are out of date, granting permission unless, and I'm going to take to Roman numeral 2, any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in this framework taken as a whole. Right, so that's the key criterion, if I can put it that way.
Yes.
Okay. If you see in subparagraph D by the word out of date, a footnote reference 8, and then if you've got the same version as I have, look down to the bottom of this page, and you'll see that 8 reads, In other words, a reference to what out of date means. This includes for applications involving the provision of housing, situations where the local planning authority cannot demonstrate a 5-year supply of deliverable housing sites with the appropriate buffer as set out in paragraph 74, or where the housing delivery test indicates that the delivery of housing was substantially below, less than 75% of the housing requirement over the previous 3 years. So you see the references there to a lack of or a failure to demonstrate a 5-year supply of deliverable, and then it says housing sites. This is the word housing is in this footnote. Is there any reason to think that the same would apply in terms of whether or not a policy is out of date if a local authority doesn't have an up-to-date 5-year supply of deliverable traveller sites?
If the policy is seeking to specify the number of or allocate a number of sites to meet an identified need, and that need that is referred to in the policy is based on an out-of-date assessment, I would accept that. But the policy is seeking to set criteria for the assessment of whether a site is acceptable in terms of its location. So I maintain my position that I believe it's not out of date.
I've probably come about this in the roundabout way, whereas I should have just said straight out, policy or the core strategy doesn't have a policy which allocates sites, does it?
It doesn't now.
Which is what's required in PPTS, isn't it?
Yes,
Identification of sites.
that's right.
So that in itself renders the core strategy as a whole out of date, doesn't it?
I don't necessarily accept that point now.
I mean, the criteria itself, you know, assuming one applies it reasonably and flexibly, is not something anybody would argue with. Yes?
That's right, yes.
Yeah.
That's in my opinion.
We can agree on that anyway. Thank you. I'm just going to check my note and see if there's anything else that, and also be told if there's anything else that I ought to address. Don't worry. Oh, the buses. Sorry. I heard you give evidence this morning about buses, and you've given us the timetables for the, I think it's the 64 and the 164 buses. Is that
Yes.
right? But I thought I heard you say there were other buses, but I'm not sure whether that's right or not.
I didn't say that.
Okay.
I'm not aware of any other bus services that would serve this site.
So it's the 2 bus routes, the 64
Yes.
and the 164.
Which to some extent overlap, I think.
Yeah, that's what I thought too. Thank you. Thank you very much.
Thank you, Mr. Willis. Right, Mr. Smythe, how long do you think you need for examination?
5 minutes.
Fine, we'll do that and then we'll have a break. Thank you.
Can we turn back to the NPPF, paragraph 11?
Yes.
Learned friend drew your attention to footnote 8,
Yes.
which provides guidance to what's meant by out of date. And you see that footnote makes a reference to paragraph 74 of the framework.
Yes.
Can we take up paragraph 74?
Yes.
And obviously read it to yourself. But if we look, paragraph 74 itself has footnote 38. Do you want to have a look at that?
Yes.
And does that provide any assistance as to what approach be taken about the application of the presumptions?
Well, it specifies for the avoidance of doubt a 5-year supply of deliverable sites for travellers. It should be assessed separately in line with policy in that document.
Thank you. And then finally, at the very end of Milena Friend's cross-examination, he suggested to you that the fact that the council does not have an adopted policy which allocates sites meant that the policy was out of date. Can we take up PPTS?
Yes.
In fact, I don't need to bring you that. I'll deal with that in closings. That's okay. I'm grateful for that. Mum, that's sorry for that. That's all the questions I have. Have you got any further questions for the witness?
Okay, thank you.
Mum, that concludes the case on behalf of the Borough Council.
Thank you.
Right, so that's the end of the council's case in opposition to the proposal. So we'll be going to have a short break, and then we will then commence the case for the appellants. So, Mr. Willers, who would you be going to call first?
Well, I'd call Mr. Adolphus Clee first, and I just can I ask whether or not we can finish his evidence today so that he's not in purdah, as it were, over the evening.
Right, let me just check.
If that's possible.
Just, have I got my time somewhere?
I think we.
What did we say? Oh, here we are. Right, so you were going to be about an hour, weren't you, with each of them?
Possibly.
So that's fine. So if we have 15 minutes, that would be 4:15, and then you were about 15 minutes, weren't you? 15, 20 minutes. Yeah.
Oh, I
fine.
thought I thought Mrs. Smythe said 50 minutes, so 15 minutes.
I've got
Okay.
15. Is that right? Or 15?
Oh,
15.
That's much. that makes timing much easier. Sorry, that was the reason why I was concerned, because I thought it was going to be a couple of hours that might be involved.
Yeah. So if we do we'll do, yes, as you said, Mr. Adolphus Clay this afternoon, and then reserve the others for tomorrow. Okay, good. So we'll come back in 15 minutes, please, at 3:10. Thank you very much. Right, ladies and gentlemen. Mr. Willis, do you want to introduce your witness, please?
Thank you.
Mum, forgive me to interrupt. Sorry, not at all. Before Mr. Willis does so, could I raise, I'm not sure it's an objection, but put a marker down. You'll know, Mum, because you're experienced in these matters, that when it comes to the lay evidence from the appellant, it's important that the witnesses are as frank and straightforward as they can, and one would expect their evidence to be in their proofs of evidence. That then gives the council and third parties 4 weeks to reflect upon it, and if they want to do some investigation, they can do that. I've got no issues with Mr. Willis asking the lay witnesses to update matters over the last 4 weeks or to put some meat on the bones. No issue with that, no issue with allowing the witness to bed in. But the prospect of an hour of evidence in chief, which must elicit new information, otherwise it wouldn't take an hour, is procedurally unfair. It does constitute an ambush. There's no good reason why this hour of evidence in chief, if it isn't updating, which I doubt it will be, but I may be proved wrong. But if it's not updating, it really ought to be in the proof of evidence. 2 final things, Mum. I don't want to be difficult. And the council wants to keep the show on the road. I'm also conscious, Mum, that you are in a difficult position because you want all the information. And it's not in your interest to close your ears to evidence to be given. So that's why I don't articulate it as an objection, because I recognise the limits and constraints in which you operate. But I hope it's helpful at this stage for me to raise what I've described as a concern. And I'm not sure how we solve it.
Mr. Willis, do you want to comment?
No, thanks. I'm happy
Right.
to.
Well, I do take the point.
Yeah.
We've only got 1 A4 plus about 6 lines.
Yeah.
So
I'm going to be trying to help the decision maker, that's you, madam, by
yes,
making sure that you have all the information you need, some of which doesn't seem to appear in the proofs of evidence, but none of it, I think, will be of a surprising nature to my own friend or the council. And I appreciate that if there is anything of that nature, then there would be a request for an adjournment, which would put us send us off the tracks, careering out of control. So the last thing we want to do is that.
right. Okay. Obviously, it's fortunate that we have a very experienced advocate for the council, Mr. Smythe. So no doubt he'll be able to take some of it in his stride. But obviously, if there is significant amounts of additional information that the council feel that haven't been able to digest and verify, then I would have to hear from Mr. Smythe on that. Okay, good. Thank you.
Good afternoon, Mr. Clee. Good afternoon. If you'd like to put your microphone on, and then maybe can you pull that contraption towards you? That's helpful. Thank you very much. And can I begin by just asking you to confirm that you are Dolphus Clee? Yes?
Yes.
And you're described in your proof of evidence as living at Plot 4, Blackbrook Nursery, Newcastle Road, Blackbrook, Newcastle Underline.
Yes.
Yeah. And that is the address that and the site that we're now concerned with. And you say that you, in your statement, and I just want to perhaps, without embarrassing you, ask you whether or not it's a statement that you are able to read yourself, or is it something that you have had read through to you?
I can't read and write. So.
You can't read and write. So has it been read through to you?
Yeah.
And am I right in thinking that you have a version which you signed, having had it read through
Yes.
to you, and your signature confirms that it's true to the
Yes.
best of your knowledge and belief?
Yes.
Thank you. So just running through as quickly as possible the details in that statement. You tell us that you live with your wife Leanne and your 2 children, Caitlin and Nicole.
Yes.
And they are twins.
Correct. Yeah.
Are they your only children?
No.
No. Do you have any? Can you tell us how many other children you have?
I have another daughter in Market Drayton.
Living in Market Drayton?
Yeah. And 2 grandchildren.
About how far from the site is Market Drayton?
I don't know. It's around about 8 miles.
You can't ask a friend.
Oh, sorry.
Okay, it's not.
Sorry.
I
I think it's about 7 or 8 miles, Market Drayton.
Yeah. Okay. So not far from the site, about
Yeah.
8 miles away. I think you said. The inspector may know the location.
So I just confirm. So it's just one daughter in Market Drayton. Is that
Daughter in
right?
Market Drayton, 2 grandchildren. Yeah.
And 2 grandchildren, and
Yeah.
they're also in Market Drayton,
Yeah.
are they? Yeah.
Thank you.
And does your daughter come to stay with you sometimes?
She's got health problems. She's she had a lot of problems in hospital.
Okay.
Everything went wrong, and she's so was anxiety, and she got like a lot of problems, you know. So it's close to us to as well. She's actually down every day, you know. So,
Mr. Clee, I can't hear a lot of what you're saying, so I'm going to ask you to bring that microphone a bit closer, because I don't think the people at the back will be able to hear if I can't hear. So you've got a daughter in Market Drayton. We won't go into the detail, but she has your grandchildren living with her children, and she's got health problems of her own.
yes.
Yeah. Okay. And help us with this, please. Daughter in Market Drayton, you're now living on this site, but where have you lived and perhaps travelled up until this point in your life? So as a child, where were you brought up? Anywhere in particular, or all over?
All over, really. And
All over this area, or all further afield?
Staffordshire, Cheshire mostly, and I've been all over like
Staffordshire,
London.
Cheshire.
I've been Yorkshire. I've been quite a long way, really.
Okay. Thank you. Now, you tell us in your proof of evidence that you make your living as a roofer, and you distribute leaflets door to door, and you work mainly in Stoke-on-Trent and the Derby areas, but then you travel away to find work 2 or 3 times a year, down to London, up to Yorkshire and the like. Always attend Appleby Fair, which is the horse fair up in Cumbria.
Yes,
And that you work your way there and back.
that's correct. Yeah.
Okay. And that you also trade in horses. And you say that you currently own 7 horses. They're on rented fields in Stoke-on-Trent and Market Drayton. And I think perhaps you're the person that the inspector might want to quiz about keeping of horses and the stables.
Yeah.
Given that you have 7 of them. I think there was a suggestion, it may be an agreement between the council and you as appellants through Mr. Brown, that only 1 horse is grazed on the field, just south of the development, and the field that you as a collective own. But the stable has, I think, 2 boxes and a tack room.
Yeah.
And Mr. Brown gave evidence about when he was asked questions by the inspector earlier on about how you might keep 2 horses on the land, but only 1 in the field, as it were. What are the kind of circumstances where you might have 2 horses on the site, but only 1 in the field and another in the box?
Well, if an horse comes ill, needs looking after.
Yep.
And also, if it's in foal, having a young one, you know, it's considered having close to you.
Yeah. So a mare in foal would be another example, would it?
Yeah.
Okay. Thank you. And you say you trade.
Sorry, Mr. Willis. Do you have a horse box?
Yeah.
And where do you keep the horse box?
On site.
It's on site.
Yeah.
Okay.
Will the inspector be able to see it if she visits tomorrow, or the?
Yeah.
Yep. Thank you.
And is it a kind of towable horse box, or are we talking about a truck with
No,
a
it's towable.
towable? Thank you. And you say that you trade in horses. So when you go to Appleby and Stowe fairs, are there any other fairs you attend?
Well, there's one in Nottingham.
Yes.
There used to be one in the Midlands, but I think that's that Nottingham one now. It's moved. And then even a smaller gathering. There's one comes in Leeds.
Yes.
There's quite a few. So they come from the calendar, and you can go for a while.
Thank you.
The horses you had, the 7 horses. So you'd have 1 on in the stables on the site.
Yeah.
Yes. And so there'd be 6 elsewhere.
Yeah.
So how far away are those?
There's not enough
horses?
grazing where we are for all of them.
No.
What was the question again?
Yeah. So where do you graze them?
I've got some in Newcastle.
In Newcastle. So that they're all, the other 6 are all on the one site at Newcastle.
Yeah.
Yeah. Okay.
At the moment.
When you go to the fair, so do you just sell through the fairs?
Just mostly for the fairs, yeah.
Right. So you'd
That's where we got to trade.
yeah. So when you trade a horse, you take the horse with you to
Yeah.
trade it. So you wouldn't necessarily trade all 6 horses or 7 horses at the same time.
Sometimes you can, yeah.
Yeah.
Or sometimes you can do a lot more. It just
Right.
depends. You could buy quite a few while you're there as well, you know.
Yeah. Yeah. So and then you'd use the horse box to bring them back from the
Yeah.
fair. Okay.
You might go with 2 and come back with 4, or go with 2 and come back with none.
Right.
It just
Okay.
depends how well it goes.
So what's the sort of average number of horses that you might have at any one time?
I've had up to 14 once.
14.
Yeah.
But is that the average, or is that just a
Average 6 or 7.
Average
Okay.
6 or 7. Yeah. Madam, I was going to ask about your reference to keeping the other horses on in Newcastle. I presume we're talking about Newcastle Underline.
Yes.
But actually your statement says on rented fields in Stoke-on-Trent and Market Drayton. I'm just wanted to check. Stoke-on-Trent and Newcastle, are you talking about the same?
No, I'm like, it's Newcastle, you know,
Right.
mostly Newcastle.
Okay. I never know where Newcastle under Lyme and Stoke-on-Trent
I get confused as
begin
well.
or end, but anyway.
So the Market Drayton reference and the Stoke-on-Trent reference, you mean the Newcastle
It's the same
site?
thing, yeah.
It's the same thing.
okay.
Okay, thank you.
Now, you tell us in your proof of evidence about where you were living before moving on to Blackbrook Nursery at Newcastle Road, Sandbach, a site owned by the Finney family. And you tell us that the pictures were only transit, no proper facilities, no outside toilet. The site was becoming overcrowded with the family of Mr. and Mrs. Finney. Is that a site that has planning permission, the
Yeah.
Finney site? Yeah, thank you. And do you know which local authority it's situated in? Which, it's not in Newcastle under Lyme, is it?
Sandbach, Cheshire.
Sandbach, Cheshire. Okay.
How many pitches is it? Or should it be?
I'm not really sure.
How many are on there then?
It's quite full. There's quite a lot on there. And then the pictures that's available mostly is one without any facilities.
Right,
And they're
okay.
just like for a quick short stay, you know?
Yes, so they're just maybe visiting family or
Yeah.
whatever that come in. Right, okay, thank you. And they wouldn't have obviously an amenity, well, if they're visiting family, they'd have access presumably to the amenity rooms of the family they're
Their
visiting.
family, yeah.
So when you were on there, were you with family then?
No, I had no toilet. So well, obviously it was somewhere to call home to come back to, you know?
Uh-huh. Okay, thank you.
So Mr. Finney allowed you to live on that site with your immediate family, with Leanne and the twins.
Yeah.
But you clubbed together, you say, with your brother and is that Thomas Lee and 2 friends? Is that the Wilsons and the Lees, Mark Lee and John and Dawn Wilson, to buy Blackbrook Nursery at auction? So at that stage, you tell us you were advised by a planning consultant, Eleanor Overton, that the site was suitable for a gypsy caravan site.
Yes.
Did you get that advice before you went to auction or after you bought it?
Before.
Before, thank you. And having bought, and can you tell us how much you paid for it as a collective?
I think it was around about 100,000, I think.
About 100,000, thank you. And the contributions, just so we understand who's paying for what, were they equally split between you or?
Equally split with
Equal,
everybody,
okay,
yeah.
thank you. And just in terms of any work that's been undertaken on the site since, again, has anybody contributed more than anybody else, or has it been an equal split?
Equal split.
Okay. And finishing off that point, if there was any grant of planning permission with conditions, for example, to lay down a membrane underneath the hard standing, to install a packaged sewage treatment plant, would that be something that one person or all of you would contribute to?
All of us.
Okay. Thank you. And again, while we're on the development side of things, Mr. Brown suggested that his clients, in other words, you and your fellow appellants, would undertake any groundwork that was required. In other words, laying of hard standing, perhaps scraping back the hard standing to lay a proper membrane.
Yeah.
Yeah. Is that right? Is he right about that? You do that manual work. And I mentioned a membrane. The inspector was interested in perhaps seeing what had been laid on the site when you created the hard standing or extended it, because I think there was some hard standing there.
That's correct, yeah.
When the site was used as a nursery. 2 things. When the inspector visits the site, will you be able to show the inspector roughly where the hard standing was?
Yeah.
For the purposes of the nursery before you ever developed it yourselves?
Yeah.
Secondly, is there anywhere on site where the inspector can see evidence of a membrane that having been laid? Yes.
Yes.
And try and speak up, Mr.
Yes.
Yeah, and where's that? Where
On the edges.
would we have to dig into it?
No, where we've put the R-core down,
Right.
you see the membrane towards the grass where it's gone on top.
Thank you. Well, again, that could be something that can be pointed out.
Can I ask, the membrane that's been put down,
Yeah,
is that a permeable membrane or impermeable?
I'm not really sure. When I put it down, I asked the supplier
Yeah.
what was suitable to go on top of grass. And,
Right.
that's the one they gave us.
Okay.
So,
And so what have you then put on top of that?
brick rubble and then R-core, like brick rubble, then clean stone, you know?
So brick rubble and then what, crushed stone on top of that?
Yeah.
So obviously, if you're going to be doing this work,
Yeah.
should permission be granted, would you have to strip all of that back to the membrane?
I'd do whatever to apply with the council. So if it has to come all off and restart again, we can, whatever needs to be done, you know?
Right.
So
Okay.
it's not there all the time. It can be moved. It's only stone, you know?
Yep. So you'd be looking to the council to give you a specification for
Yeah.
putting down either an impermeable or permeable, depending on which one they went
That's
for.
correct.
Right. Okay. Okay. Thank you.
Thank you. So I think it was suggested by my learned friend in opening that the inspector couldn't be convinced or confident of the fact that you and your fellow appellants would comply with any conditions that she might impose on the grant of plan permission. Do you understand the point?
No.
Okay. If the inspector granted planning permission with a condition that you install a sewage treatment plant
Yes.
and a membrane which complies with the council's
Yeah.
requirements, would you comply with that?
Yes.
Thank you. And would you have, I mean, you've heard the sort of money that Mr. Brown was talking about for a sewage package treatment plant, let's say £5,000, let's say £10,000 at the outside. Would you be able as a group to raise that money?
Yes.
And install one? Thank you.
I mean, you've already spent quite a lot on the site, haven't you? You've already put down the membrane, you've put the planings and then the crushed stone on top. You put the fencing painted green and all that planting as well. So you've obviously spent quite a lot, would you say, already?
I spent quite a bit, but just try and make it look a little bit, obviously, it looks, when you drive past, it does look clean, you know. We're not hillbillies or anything like that, you know.
Yeah. And was the cesspit on the site already, or have you installed that?
I've got a video of that. From I've got we put that in as we got there. It was put straight in.
Right. So you've installed
as we're getting
that.
Developed. By the Monday, it was all done. They put in reinforcement, and it was by, I think, Thursday or Friday, but it was all finished by Monday. So nothing else from that day has gone any farther.
No. Okay.
And the stables was told, as long as they're movable, you don't need planning permission.
Okay.
So they're on a sledge.
Okay. Well, I'm sure Mrs. Moulton's taking some advice from the enforcement officer on what he said about that. But anyway, so but you did install the cesspit when you first moved on.
Yeah.
What would that have cost?
It's just a sealed tank.
Yeah.
I think it's about £1,000, I think.
Okay.
To put it simply, is it a case of digging a hole, dropping it into it, and then connecting it up to the either toilets or toilet facilities?
That's correct. Yeah, straight to toilet facilities.
Yeah. And then presumably that has to be emptied on a regular basis.
On a regular basis, yeah.
And does that happen? Do you have
got quite a few people who does it. There's a farmer in Market Drayton, A.R. Richards is it. And then there's another bloke from Stafford. He's been over a couple of times as well.
Right.
Because if it's getting full, you need to get somebody, the quickest person to empty it for you.
Right. Thank you. And on the point about the stables, was it you that talked to, or I suggested to, let me put it without leading, I suggested to Mrs. Moulton, you'd have heard that a discussion was had with Mr. Lehman, who was the planning enforcing officer, Paul Lehman, about whether or not permission was required for the stable.
Yeah.
And the advice apparently given was that it could be installed or it could be situated on the site provided it was movable. Did you have that discussion or did somebody else?
Yeah, I had that discussion. All it was, he said, you're not allowed to put any concrete base down to put the stable on. It has to be movable.
Right.
On a sledge, so that's what it is. That's why the caravans are not on a, everything's just movable.
Right.
There's no concrete there at all, you know?
Okay, thank you.
But just on the stables, so it's obviously not on a hard surfaced base.
It's on grass, and we've got rubber mats to put inside the stable.
Right.
About
Okay.
that thick.
Yeah. I mean, obviously, I'll
Yeah.
see that when I come
Yeah.
down to the site visit. But in terms of it being movable, it is quite a large building. So how
Yeah.
did you move it? Because it's been moved. It has been moved,
Yeah, well,
hasn't
you
it?
can tow it. It's on a sledge, or
Right.
you can dismantle it. You know, so it depends on what you want to do.
How did you move it from, I think it was on the western boundary to the east? Did you dismantle it or tow
I
it?
dismantled it and put it back up again. The reason being why we've got fences up and conifers or whatever to drag it. It would have moved all them, so we just in a couple of hours took it down and put it back up again.
So you took it down
Yeah.
and then re-erected it
Yeah.
again.
Okay.
But you're saying you could move
You'll
it.
see when you get there. It's got the hook on just to tow it.
Right.
So
Thank you. Now, having bought the site at auction, an application was made for planning permission. I think I'm right in saying that another planning consultant, Alison Heiner, was representing you at that time. Is that right?
she has represented us, yeah.
She was your planner. And that application was refused. And did you do anything as a result? What was your next move?
When it got refused,
Yes,
we put an auction to sell it.
you tried to sell it.
Yeah.
And you tried to sell it at auction.
Back in the auction, same auction, yeah.
And what was the outcome of that?
It didn't make nowhere near the reserve price.
Didn't make the reserve price. Okay.
Or nowhere near it, you know.
And what was your intention had you sold it for the reserve price or something more?
Well, it was refused planning, and so we tried to sell it. And obviously, if we sold it, we would have kept the money together to buy somewhere else.
Right.
But as it never sold, we was forced into a corner where we had nowhere to go with it, you know.
Okay.
So that would have been the strategy. So you'd have sold the site and then used the money to buy
Elsewhere.
somewhere else. So where would you have gone between the sale and finding another piece of
Before
land?
we bought the property, Eleanor Overton, she advised us to buy it. She said it was a good plot for. So we'd done the same thing again. We'd have found somewhere else and asked if that was a good plot before we brought it. So-
Right. So would you, because obviously it didn't work out well buying
No.
it and then finding you couldn't get planning permission on
No.
it. So would you have considered applying for planning permission on
Apply
another
for-
site?
Yeah. We tried planning permission, we applied for it then, they refused us.
Yeah.
And then because we couldn't sell it, we had where I was living at, I don't know if tell me story, it was overcrowded. And
Yes.
obviously people come and go and they have a lot of grandchildren that gets married and needs permanent spots.
Yeah.
Even though I wasn't on a permanent spot, you was not going to get one.
Yeah.
So
okay.
it was either be on the side of the road or be there. So it was on Turdy pushed to there.
Okay. So if you'd have sold the site you're on now,
Yeah.
and hadn't been able to find somewhere else, what would you have done then? What's the interim? What would you do?
Already looked at the internet. There's quite a few other places for sale that we may be able to go back to another auction.
Okay, so really the strategy would be just to find another site, buy that, and then move on to that,
put in permission or move on.
and then put in for permission once you're on it. Is that it?
Or put in permission like we did first of all,
Yeah.
without moving on there. It was so. Otherwise, we did it first. We put permission was not back. We couldn't sell it.
Yeah,
And then
yeah.
obviously, without
Yeah.
the money, you had nowhere else to go.
So when you bought the site, first of all, did you said you put in permission
Yeah.
at that stage? You didn't actually move on to it.
No.
You put the planning application in.
Yeah.
And while that was being processed, you then found that you needed to get off the Finney site.
That's correct.
And so you just moved on there.
Yes.
Yeah. Okay. All right. Thank you.
Just to clarify, I think, forgive me if I'm wrong about this, but my understanding of the history is you bought the site through auction, applied for planning permission. You were still with the Finneys at this stage.
Yes.
You got refused permission.
Yes.
You tried to sell the site by auction.
Yes.
And then when you failed to sell it, there was a issue. You had to leave the Finney site and you moved on to this site. Is that
Yeah.
right?
That's
So
correct.
it wasn't until after the refusal of planning permission. So yeah, I don't think there's any dispute about the timing. No, yeah. What happened at auction may not be in the council's knowledge. I don't know, but So you I think, and I didn't quite hear. So again, if you can try and keep your voice up, Mr. Clee, you were telling the inspector that you were in a position where you were forced to move off the Finney site. I mean, because of the issue being, I think you told the inspector, but just remind us, what was the reason why you had to leave the Finney site?
It was overcrowded. There was no more space.
Okay, thank you. And was anybody else on the Finney site with you? Any other members of the
My brother.
group? Your brother,
Yeah.
Thomas Clee, and his family. Thank you. Now, let's just assume well, perhaps before we think about the future, let's just look at the end of your statement, please, Madam, where Mr. Clee says, since moving on to Blackbrook Nursery, we've been able to provide ourselves with a mobile home, registered with the doctors at Madeley. Leanne, your wife, suffers from arthritis in her knee and shoulder, and you tell us needs to be in the warmth of a mobile home during the winter. And then you don't tell us about the health of your two children, Caitlin and Nicole, but are they fit and healthy?
They're asthmatic.
They're asthmatic.
Yeah.
So what do they have any treatment for their asthma?
They're pumps.
Okay. And have they been asthmatic since birth, or are they?
Yeah.
Is it something that, okay. And it doesn't. Their treatment doesn't involve admission to hospital. They don't have to go to hospital, or do they?
They take the pump.
Yeah. So that's how it's controlled.
Yeah.
Okay. Thank you. And yourself, are you fit and healthy?
I'm okay. Yeah.
You're okay. All right. You tell us that we do our main food shopping in Newcastle and Market Drayton, but also shop for food in Loggerheads, where there's a co-op, chemist, post office, butcher's, hairdressers, and 2 takeaways. And that you buy daily essentials from the local farm shop. And we know now where that is. It's up to the A51 and then along the road. You tell us that you've walked to the farm shop on occasions. Just to describe the route as you come out of your driveway.
Yeah.
The inspector will see, but I think Mrs. Moulton said often the verge is overgrown.
Yeah.
What, as an adult, let's not talk about children at this point, or disabled children for that matter, but as an adult, what was your experience of walking up that, what I think everybody agrees is a busy road?
It's a busy road, yeah.
Yeah.
Obviously, if it's a Sunday morning, it's not really too bad.
Right.
You know, but mostly it's easy to drive, like, you know.
Yes.
But if you want a bit of exercise, well, it's just a 5-minute walk.
Right. So it's a 5-minute walk. As an adult, did you fear for your life as you were walking up the road?
Not really, no, because I just walked the grass verge.
Right. Okay. But is it the sort of walk that you would want your twin daughters to take? I mean, is it something? Is it dangerous enough for you to say to Caitlin, you're not going out of that?
It'd be a lot easier for me just to drive them where they need to go.
It's a lot easier for you to drive them where they want to go. And that's the reality, is it? Yeah. Okay. You tell us about Tom jogging, but I'll leave that to Tom because presumably you're not on the jog with him. And at the farm shop, I haven't been to the farm shop. What can you buy there? And the inspector might go and
bread,
visit.
milk, cakes, accessories. There's quite a bit in there.
Okay. Thank you. It may not be suggested to you by my learned friend, but tell me about this. Your life as a Romany, you're a Romany gypsy, yes? Yeah. You're living in caravans and mobile homes, but have you ever lived in bricks and mortar? In other words, in houses? What's your view about doing so?
To live in a house, it became to be culture.
Yes.
Like I live in a caravan. Mobile home's a lot better than the caravan because it's more warmer.
Yes.
You've got your own proper toilet facility, and it's just a lot more convenient, you know.
Yes. But if it was suggested to you, it probably won't be, but that you should move into a house instead of living your traditional way of life, what would you say to that?
No.
No. Okay. And
sorry, Mr. Willis, can I ask your daughter and your grandchildren? They live at Market Drayton. So are they on a site in Market Drayton?
They're on the Market Drayton. It's their own site.
Their own
site. It's not their own site. It's like a family of, I think it's 6 there. and they've got their own
They've got
mobile
their,
home.
right. Okay, thank you.
Thank you. So I want to ask you then about other alternatives. And you say in your evidence here, your brother Tom went to a public site at Silverdale. Is that the Cemetery Road site?
Yeah, it's pretty full. I think it's mostly family, and I think grandparents need to die to get on there. You know, I think it's
Right. So it's a case of people popping off and then
Yeah.
and then vacancies coming as a result of that. You said it's all family. What did you mean by that?
I think when you go on there, it gives you a funny turn. Like, I think there's a lot of one family towards the top of it.
Right.
And,
so there's a predominant family.
Yeah, but I think it's very, very rare that you can, if you could get on there anyway. Which the council should know that, because people was waiting.
And Thomas will tell us what he was told about the numbers on the waiting list. But you said you also tried to find pitches on a site at Reelshaw Lane, Winsford.
Yeah.
That's already overcrowded. And then you explained that that's the reason why, effectively, when you had to move off the Sandbach site, Mr. Finney's site, you either moved onto your land or the roadside.
That's correct.
Now, let's think about the future. If the inspector were to find against you and to conclude that planning permission should not be granted either permanently or temporarily, what options, if any, do you have as a family?
Be on the roadside.
The roadside. Is there any other option? Is there anywhere else that you know of that you could go to?
No.
Right. And what impact?
Hang on, Mr. Willis. So you said that you're obviously able to go on to Mr. Finney's site. So
Yeah.
presumably Mr. Finney was a friend who was accommodating. Is that right? Yeah. And do you have other friends who have got sites?
No.
Okay. And what about your family? Because you say Cemetery Road is very dominated by one
Yeah.
particular family. So where are your family living?
On Blackbrook.
On yeah.
That's where I'm at, yeah.
So your parents, your cousins, they're all on Blackbrook.
No, my mum lives with a brother.
Okay.
And then obviously my daughter lives in
Yes, in Market Drayton. So is your mum and your brother local?
My brother lives with me on Blackbrook.
Right. Okay.
And your mother?
Stafford.
Stafford. But is there any? Does she live on a site? And if so, are there any spaces on there?
She lives on a site, yeah, and there's no spaces. You'll see if you go there, it's overcrowded, you know.
Is that a local authority site or a private site or
It's a private site.
private site?
Yeah.
So there's no availability there either. I mean, there's no suggestion that there is any availability anywhere else, but we're just trying to explore what options you might.
Yes.
No
Yeah.
availability.
Okay.
Have you lived on the roadside before?
Nearly all my life, yeah. All my
I
life.
mean, literally the roadside.
Yeah. On the
the
yes.
roadside,
Yeah.
yeah.
I mean, yes. I mean, you're very open at the beginning and explained that you've done
Yeah.
a lot of travelling
Hmm.
around the country, mainly Cheshire and Stafford, and so presumably that was as a young boy you were with your parents, presumably.
correct, yeah.
And they were travelling around on the roadside then, or from
That's correct, yeah.
from site to site.
From roadside, aside if you can get on one,
Mm.
but mostly roadside.
Okay. So in more recent years, have you done a lot of travelling on the roadside?
Quite a bit, yeah. If we're going to Appleby, it takes a few weeks to get there.
Yeah.
So, well, you can go there a day, really, but you go quite a few weeks before, travel your way up, and then work, and then
Yeah. And when you go travelling for work, do you take
Yeah.
the family with you?
most of the time, yeah.
Right. So they, because you obviously got the twins.
Yeah.
So they would normally go with you when you travel for work.
Yeah.
Okay. Thank you.
And perhaps just following on from that, the twins, as I understand it, are currently. You tell me, what's their educational the position as far as education is concerned? Are they receiving any sort of education?
They get on home tutors at the moment, yeah.
Okay. Well, we've got a letter from Mrs. Lynn Jones, a private tutor. She says she's been tutoring children on this site for a number of years. Is she your daughter's tutor?
Yeah.
And the other point is this: if you're granted planning permission, indeed, perhaps tell us what's been happening in the time that you've been on the site. If you're granted planning permission, what does it mean for your ability to travel and who you take with you when you're traveling for work?
I don't understand the question.
Okay, well, that's me probably trying to lead you somewhere you don't need to go. I think I'll leave it there. Thank you very much. If you wait there, there'll be some questions. Thank you.
Afternoon, Mr. Clee.
Yeah.
When did you buy the site at auction?
I forget now. It's quite a few years ago. I think Mark or somebody will know the date when we brought it.
Perhaps I'll ask you a different question. How long before you submitted the first planning application did you buy the land?
Before we brought it, well, obviously everybody knew it was an auction when it was about I don't know, maybe 2 or 3 months after, was it? Something like that, a month, 2 or 3 months.
Do you own any other land?
No.
When you moved on to the site to live there, did you realise you needed planning permission?
We put in for planning permission before and we was denied it and we had no choice to go there.
So I take that as a yes.
Yeah, it was over on the other side of the road.
Yeah. And before starting the residential occupation, before living on the site, did you ask for any advice from Mr. Brown about whether that be a good idea or not?
What do you mean?
Well, you knew that you needed planning permission.
Yeah.
You'd submitted the planning application.
And then we moved on.
Yes. Planning permission had not yet been granted. And so you jumped the gun by living there. Did you seek any advice from anyone, including Mr. Brown, about whether that be a good idea or not?
No.
When you moved on, was there already mains, electricity and water, or did you get that connected?
That was already connected. I had it put on well before.
Can I just clarify that? So when you moved on, it got mains running water.
Yeah.
And there was mains electricity.
Yeah, I put it on there, yeah.
Yeah, because there was some mention of a generator. So why did you have the generator?
The generator came up a lot of times in the past. It was there for about a week because
Okay.
the reason why the electric wasn't connected. So that it took a week for the electric board to switch it on.
Right, okay.
That's why we ran on the generator for about 4 or 5 days.
Okay, all right, thank you.
So when you bought the land at auction around 2018, did you plan at that stage to live on it?
Well, that's why we put in for planning permission to live on it.
Your proof of evidence doesn't mention at all anything about the first planning application. Where were you living when that planning application was submitted?
Sandmatch.
Sandmatch. And when did you first move on to the Finney site?
Oh, quite a few years before that.
What year was that?
I've been on and off there travelling about, and obviously when you ring, you'll ring around trying to get availability. If you can't, you got to stop on the side of the road. But obviously when you're on there for a while, you intend to be left alone for quite a bit. But as soon as obviously your family or member needs to come on their own, you've got to move. So it's only a certain amount of time you can have on Finney's if you're not residential, you know.
When you're living on the Finney site, were you in a touring caravan?
Yeah.
Yeah. And so when you went travelling, you'd obviously the touring caravan, you'd
They went
take
with
it
me,
with
yeah.
you. That's right. So would they keep your spot for you while you were travelling so that when you came back, you'd be able to go back onto the Finney site?
If I was going to Appleby, it'd take about 2 to 3 weeks. They let me keep it for 2, yeah.
They would. Okay, so they keep it for a couple of weeks for you
Yeah.
while you went travelling, then you'd have
Yeah.
to come back or you'd
Yeah.
lose your spot.
That's right, yeah.
Yeah, okay. And so roughly how long do you think you were there? Obviously you're going backwards and forwards, a couple of years or?
Probably 7 or 8 years.
Oh, as long as that, okay. And over that time, you still had no facilities, so that you had no access to facilities.
There's a service station around the back.
Okay.
Some services, but you just use the toilet in the caravan.
Yes, yeah. So for showering and that sort of thing, you had no shower So
not a proper one, no.
no, okay. But that was for 7 or 8 years that you were living in those conditions while you're on the Finney site.
Yeah, but while I was there and back and forth.
Yeah, of course, yes, yeah. But you're only being able to go away for a couple of weeks to come back because they would only keep you spot for a couple of weeks.
Yeah.
Is that right?
Yeah, you couldn't sail back next year and it'd be waiting for you. That wouldn't happen.
Okay, all right, thank you.
So if you had been living on the Finney site on and off for about 7 or 8 years, that means you first started living there about 2012 or 2013. Does that sound about right?
Yeah.
And where were you living before you started living on the Finney site?
I was travelling.
Just travelling. So nowhere.
No, just travelling, yeah.
And
sorry, Mrs. Marcus. I just want to clarify one point. So you were on the Sandbach site for seven or 8 years.
Yeah.
Now the reason why you had to get off the Sandbach site after all that time, can you just explain that to me again?
Sometimes they get a bit overcrowded.
Yeah.
And then obviously they've got a lot of grandchildren and stuff like that. So if they're getting married, there'd be less space. And that's what happened at the end.
Right. So this is the family, the Finney family. As their children get older, the grandchildren come along,
Obviously,
they need the spots.
Somewhere to live, yeah.
And basically you then have to move off because you're not family.
That's right.
Is that it? Okay, thank you.
Is it right that the first time the 4 families were all living on the same site together is when they moved on to the appeal site?
We all moved on there together, yeah.
Yes.
Me and my brother was together.
Yeah, understood that. Yes. And in respect of the Wilson family and the Lee family, where were they living before they moved onto the site?
They were at Stafford.
Stafford site. And were they on the same site or different sites?
Different
sites. And so which site were the Wilson families living at?
On number 2 Withens, I think.
2
Withens.
Withens, yes. Withens Lane, yes. Yeah. And what about the Lee family?
I think he was on number 1, I think.
So same site, different pictures?
Yeah.
Yeah, understood. Okay. You submit a planning application, so you instruct and pay Mr. Brown to prepare the application to draft a layout plan, and then you move on to the land. Why don't you position the caravans and the stables at the position which you'd instructed Mr. Brown to draft the layout plans for you?
Because time we moved on, and then we'd done the development, and before we could move everything around, the council put a reinforcement on us. So before we could alter everything to be settled, we had a reinforcement on us that we couldn't do anything else to the land.
Right, but why would that stop you from moving caravans into position?
Well, what would be the point when you haven't got the actual pitch to the whole lot to move it? And if you look when you come down, we're very crammed, and we haven't got for the planning application, we haven't got the room that we've put in for to do that.
Yeah, because
so we'll just make good of a bad situation.
You've been living on the site now for 17 months, haven't you?
Must have been, yeah.
So you've had 17 months, and you could have reconfigured or swapped around the structures so they're in the correct position as far as a layout plan is concerned.
But we've got a reinforcement on us, so we can't move anything.
Right, so you think you can't move anything?
Well, the was told not to put no concrete bases down or to alter any more than build any farther than what we are. So we just want to put no more stone down or anything more than what we've already got.
Can I just check that? So the terms of the injunction, does it stops additional caravans going onto the site? Is that right? And what about things like putting hard standings down and right? Okay, so Mr. Clay's right in that they couldn't. They would be in breach of the injunction if they carried out any engineering works in terms of creating hard standings for the caravans. Is that right?
That's right.
Right. Okay. Thank you. You had understand that correctly.
Yeah.
Yeah.
So, yeah, so that's how I'm going to have it.
But if planning permission is granted by this inspector, you're saying that you will switch around the site so that it reflects the plan which Mr. Brown has drawn up on your behalf.
That's correct, yeah.
And why were the stables moved?
The stables have been moved. If you look over the back where there was near the trees, we're pulling out to the middle. It's going to be very dark soon, so we can see the horse for the window when it's having its foals and stuff. So we're going to put a security light so it flashes when we walk to it, you know. So it's just been moved.
Sorry, where was it moved from?
It was the other side of the field,
Right.
so we just fudged it closer to us.
Oh, right. So it was right the other side of the field, not
It was-
close to the caravans.
No, you know, when you come to the gateway,
Yes.
look at the far edge. It was there.
Yeah. Oh, right. Okay. So on the far side of the field.
Yeah.
Right. Okay. And now you've moved it so it's sort of more central.
Yeah.
And it's facing towards the caravans, isn't
Yeah.
it? So you can see the
You
horses
can
from
see it,
there.
yeah.
Okay. All right. Thank you.
And when were the conifers planted on the boundary?
They had them back in the summer.
Summer this year?
Yeah.
And whose idea was it to plant the conifers?
Mine.
And did you take any advice from Mr. Brown about the sort of species you might choose to plant? Or did you decide off your own bat?
We've made like somewhere safe for the kids to play, and obviously the conifers for screening, and obviously it's a paddock.
Understood, but the choice of, you could have chosen another species, a different type of tree. Why did you choose conifer?
It was the only one that was available.
So that the plan that's been submitted shows us acoustic. We've heard about the acoustic fence on the eastern side near the road, and Mr. Brown has said that the rest of the site will be in post and rail fencing.
Yeah.
With some landscaping.
Yeah.
Now, obviously, what you've just said about planting strikes me. There's maybe a concern for you about visibility in terms of where the children are playing and that sort of thing. So taking down that fence,
Yeah.
would that make a difference to you?
Whatever needs to be done for the council, we'll go ahead, you know. So if they say the fence has got to come down, whatever needs to be done.
Okay.
If I'm on the right question.
Obviously, taking the fence down opens things up more to view.
Yeah. So whatever needs to be done, I'll carry on. And obviously, whatever they ask me to do, we'll do. You know. So apart from that, I'm a bit lost on the question.
Okay. All right.
Perhaps I'll have a go.
Yeah.
Ignore what you think the council does. What was your preference? If you had a clean sheet, would you prefer to have conifers and the close boarding fence, which gives you privacy and safety for your children?
If I had a clean sheet,
yes,
I would. When they put the reinforcement, they told us to not put any more stone down or extend it to any differently than what it was already on. If I had a preference, I'd discuss Mr. Brown's plans and go from there. But obviously, I've been thought that we're stuck in a position where we couldn't actually change the development of the property. But to put a conifer edge up, it doesn't really mean that it's permanent. If I had to come out, you can pull it out, can't you? They could be moved. But obviously, I don't know how your home is, but if you like to call somewhere home, you like just to do it so it looks a little bit nice, you know? And I thought the screening was nice.
Yeah, okay.
And obviously, when we fetch the horses around, it's tidy.
Do you know, is Charlene Fury, is that a family member of yours?
It's my family member, yeah.
Is that your mum, your mother?
Miss me cousin.
Your cousin, okay. And do you remember being served with the injunction?
Yeah.
Court papers?
Yeah.
And because you don't read, was that read to you, or did someone else in the family?
My wife can read.
Your wife read it to you?
Yeah.
Okay. And so when your wife read it to you, you appreciated it was an important document, which you ought to do your very, very best to obey. Who was responsible for erecting or assembling the children's play equipment?
The play equipment.
Yes.
I brought it on Facebook.
Right.
Well, we brought it on Facebook.
And when was it? So it was delivered and then you assembled it?
No, I brought it on Facebook. I went with a low loader, put it on and fudged it home.
Right. So in one piece?
Yeah. Well, 2 pieces screwed back together.
Yeah. And when was that put on the land?
I think it was back in the summer, last summer, was it? It was a while ago, quite a few months ago.
This summer, so summer this year or summer last year?
I think it was last year, I think. It was last year.
Okay. You told the
The playground's only, it's not permanent, the playground, it's only wood. It can be taken down and it's not permanent there, it's just some wood.
Yeah, it's not fixed to the ground,
No,
it's resting on the ground.
It's a wooden playground.
Yeah, I understand. You've explained to the inquiry that after your planning application was refused by the council, the first one, you tried to sell the land at auction.
Yes.
Why didn't you appeal that?
What do you mean? Because the way we've seen it, when we put back in the auction, is that we wasn't going to get permission to be just allowed to put permission and move on. And then so we thought, if we buy somewhere else, we might have some better luck putting for the council and get it, permission to live there. But with it never selling, we had no alternative to, well, we're stuck with it really.
So, I mean, none of this is in your proof.
Yeah.
But the auction, did you go back to the same place where you bought it at auction to sell it?
Yeah.
Right. And when did you put it to try and sell it yourself at auction?
I know it's me who's on the spot here, but I think Mark's the best one to ask for that because he knows more about dates. I can't read them right.
That's fine. I'll ask Mark. That's fine. Okay. And what was the reserve price, which you say wasn't met, which meant there wasn't a sale?
Well, we've tried to get our money back to what it cost, and obviously it didn't make nowhere near that. So that's why we still got it.
So the reserve price was about 100,000.
Yeah.
And there's no documentary evidence. You haven't got any records from the auction house. Because presumably someone went to the land to take photographs, didn't they? To put them on the website.
They went to auction. Yeah.
Yeah. Okay. And do you know where the Wilson and Lee family were living before they moved onto the site in Stafford?
I answered that earlier on.
They were at the Within Lane site, pictures 1 and 2. Before then, do you know where they were living?
Yeah, I think John was at Yorkshire and it's like around an area like, but obviously when I bought that with him, he was at Stafford. So
yes,
his business is down to himself.
I understand. And the Wilson family, do you know where they were living before they lived in Within Lane, Stafford site?
That's the question you just asked me, isn't it?
I thought you said John Lee.
No, Mark Lee is.
Oh,
Mark
yeah,
Lee
yeah,
was,
yeah.
I think you just answered.
Yeah, sorry, yeah.
You weren't answering where Mr. Lee.
Yeah.
Well, Mark Lee is.
You can presumably ask them.
I can do.
Yes.
Yeah.
And say for the child who attends the special needs school, do all the other children who attend school, they are dropped off at school and collected from school by car, is that right?
That's correct.
Yeah.
Do the twins have tutor? They don't go to
tutor.
school?
No,
No.
they've got very bad asthma.
Okay.
And with COVID and stuff, that's when we've been living on there through COVID. And I wouldn't put any of the kids at risk. So
They were at school prior to the pandemic.
Yeah.
Yes.
they've been to school, yeah.
Yeah. Okay. Thank you.
Thank you, Mel. That's all the questions I have.
I have a couple of follow-up questions, if I may, please, Madam. You told us about the site and the way that the mobile homes are currently situated. You described it as being quite cramped.
Yeah.
Mr. Brown has explained that the plan would involve removing the glass houses and extending the size of the site, but you haven't done any of that work. The
No.
inspector will still see the glass
Everything's
houses.
original to where it was when we came, except for the piece in the middle that we've moved on to.
Yeah,
And some of that was outstanding.
Yeah, thank you. Then the other point I was going to ask you about, please, is one you just mentioned in answer to my own friend's questions about your twins and their tutoring. You said they don't go to school, or they haven't been to school whilst on site, and you mentioned COVID. And I appreciate they've got asthma, and you mentioned COVID, but just explain what your thoughts are in relation to them going to school with their conditions whilst we're all in the middle of a pandemic.
I don't understand what you're saying.
But why is it you haven't wanted to send them to school?
They're suffering with asthma.
Yeah.
And also they're getting to an age where obviously mum needs help.
Yeah.
And it's culture as well, really. At a certain age, we take our kids out of school.
Right. So it's not just about COVID.
No.
Is the reason why they're being tutored, just so the inspector doesn't go away with the wrong impression, is it partially to do with COVID and their asthmatic condition, or is it actually more your view that they should be
Why
tutored?
they're getting
at home?
tutored? Well, I can't read and write.
Yes.
And I find life very difficult.
Right.
If it wasn't for my wife reading and writing, I'd be stuck more than once. And obviously I want my kids to have some sort of an education.
Right. But that doesn't, you want them to have an education, they've got a tutor, but not an education in school at this point in their,
That's correct, yeah.
in their lives. Okay. And is that because of your concern, is that because of your cultural views, or is it because of COVID,
It's
or
COVID
is it a
and
bit
culture.
of both? Okay, I think cultural
Okay, so it's
Preference,
cultural
yeah.
preference rather than
Yeah,
than COVID.
COVID.
Yeah,
asthmatic
that's correct,
preference.
Yeah, okay, thank you.
I'll make a note of that.
Yeah, no, thank you. Very much.
Obviously that's your children, and obviously I'm going to hear from the rest of the family, but are there other children that go to school on the
Yeah.
site? There are.
Yeah.
Okay, right, I'll ask the questions of the others then.
Yeah.
Thank you.
Thank you very much, Mr. Clee. I think unless the inspector has any other questions, that's your evidence.
okay, thank you.
If you turn off your button, thank you very much. Entirely in your hands, but we've probably done quite a lot today.
Yes. So I was going to say that we're going to finish for the day now, and timing wise, I'm sure you'll let me know if you think this isn't realistic. I'm thinking tomorrow we'll start at 9:30. That we'll hear from the appellants in the morning, and I'm hoping that we'd get them all finished in the morning, and then we can start Mr. Brown in the afternoon. And looking at the timings, we should be able to finish Mr. Brown tomorrow afternoon as well. Yeah. So in that case, I'll do the site visit on Thursday morning. I haven't looked at the weather forecast, so I'm hoping it's not going to not be too rainy. But anyway, do the site visit on Thursday morning, and then come back and do the condition session and closings on Thursday afternoon. Does that suit you two gentlemen?
It does, but equally, it would perhaps it would more suit certainly me, but possibly my own friend, if you had the site visit after closing submissions.
No.
But some inspectors
No,
don't
I
do that.
prefer
others are happy.
Well, here we are. It's 4:10. It's already lights failing, and it's been failing since probably about 3 o'clock. So I'm a bit reluctant to do it too late. I prefer to do it in the morning when we've got good sunlight.
So-
Also, hopefully it's going to be sunlight, but good daylight anyway. Also, often advocates are more than happy to do it because it gives you the morning to get your closing sorted.
Yep.
So I'd prefer to do it on Thursday morning, really. And I'm going to, just to let Mr. Mannering know, I'm going to do a site visit in the dark, but I'll do that on my own. So it'll be one evening before the end of the inquiry. I'll have a drive down there so I can see the site in darkness, just to let you know, Mr. Mannering. But I won't be doing the bus ride, I'm afraid. So thank you for the offer of accompanying me, but I'm not sure that I would really get any great benefit from that. I will note where the bus stops are, though, definitely, when I do my site visit.
Walk from the bus stop on the A51 down to the site, in the darkness, you will see exactly what I was talking.
Okay, thank you. All right.
And Madam, the only other thing is that I'm hopeful, but obviously it's optimistic that we might deal with conditions tomorrow afternoon.
Yes, absolutely. If
we do
if
that,
we've got
then
time, yeah, then
then
absolutely.
perfect.
Yeah. But I mean, even if we don't, I wouldn't anticipate that would take too long. And the sort of timings you've given me for closings, we should be able to complete all the business, including the site visit, by the end of Thursday. All right?
Thank you.
Good. Okay, thank you very much. Anything else anybody wants to raise? No? Okay. I will see you all back here in the room at 9:30 then. Thank you very much.